Yes, Judge. Sean Abuhoff and Kathleen Hogue on behalf of the state.
Sabrina Puglisi and Frank Prieto on behalf of Courtney Clenney, who is present before the court.
Good afternoon, Your Honor.
So, to answer your question, Judge, in regards to the medical examiner, he'll be here at 2 o'clock. I believe we're going to allow for defense to go out of turn and call a witness beforehand. And there are a couple of items from a discovery standpoint I don't believe anybody's objecting to that we will probably move into evidence and publish to Your Honor.
In the state of the defense, let's see the defense is analysis or the Vivian O'Neill's written statement and listening to hopefully that objection to the court statement from her as well.
And Judge, here are the bank records, which will be addressed with Mr. Clenney. This is the copy for the court.
And I've had an opportunity to review them. I don't have an objection to them.
Do you have an objection to the reported statement and the
No, Judge. For purpose of Arthur, it certainly can come in.
All right, so we'll go ahead and allow all those things to be evidence as defense exhibits without objection. Okay. All right, so then we're going to go ahead and start with
Mr.
Murd.
Kim Clenney.
Okay, so Ms. Clenney first.
Mr. Clenney?
Or Mr. Clenney.
Please raise your right hand. You swear or affirm the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? I do.
Could you please tell us your name?
Kim Clenney.
And how do you know Courtney?
I'm her father.
Now, Mr. Clenney, you've been called today for phase 2, specifically with respect to financials, so that's what we're going to be discussing today, okay?
Okay.
I see you have a folder there with you. Can you tell us what you have brought with you today?
There's just notes as far as numbers regarding the different accounts and wire transfers and expenses.
Okay, so I would just ask this as we talk about this today. If you need to refresh your recollection at any time, please feel free to do so. If you could just say that you need to do that so that we can be made aware of it, and you can't read from the records, okay? So just then close it up and answer the question, okay? All right, thank you. So let's start. Let's go to wire transfers. At some point in time, were wire transfers made to an account that you have?
Yes.
Okay. And generally, around what time was that?
Mid-April and then early May.
Okay.
There were 3 total.
Now, can you explain to us why those transfers were made?
Well, after April 3rd, Courtney was a mess. I didn't really trust her to handle her finances. One important thing was that her debit card for one of her accounts was not found, and we didn't know who had it or had access to her accounts. So we felt like a prudent thing to do would be to transfer the money into one of our kind of dormant accounts and then safeguard it that way, and then as she needed it, we could use it on her benefit.
Now, you used the word she was a mess. Can you just generally describe what you mean by that?
Well, she's been traumatized for quite some time, but especially after April 3rd, and then she was drinking heavily.
Okay. And so with the drinking heavily and the traumatization, you felt that she could not adequately take care of her finances?
Yes.
Yes, okay. So to your knowledge, how many bank accounts did Courtney have?
At Bank of America, she had 3. One had a 0 balance when I accessed them, and there were 2 others that she had funds in.
And let's talk about those transfers that were made to you. The first transfer, do you recall when that was?
I'm going to refer to my notes.
Yes, you may. Does it seem like the...
I'm so tall. I can lay down. So the first wires from one account ending in, well, the first wires were on April 12th of this year. There was one wire for $121,000, one wire for $1,013,000, and then subsequently in May, there was a $50,000 wire as well.
Okay. And these transfers came from, to be clear, the two Bank of America accounts that you know to be associated with Courtney, ending in 2923 and 1712?
Yes.
Before we get into the amount in the Wells Fargo, let's just go back to the Bank of America. Once those transfers were made, how much money was left in those Bank of America accounts?
Refer to the notes again.
Yes.
In the account ending in 2923, the balance after the wires was $4,839.24. The account ending in 1712, there was $466.88.
And can you tell us the total of those two numbers?
The total of those two numbers, a little over $5,300.
Okay. Let me take a look, because I think my math is a little bit different. Judge, may I approach Mr. Clenney? I'm showing you the document from Defense Exhibit V. I believe, Judge, is it V that was introduced for the records? Thank you. I'm showing you this document, and
Right.
do you see that document?
Sorry, I misunderstood the question. I was giving you the balance the days after the wire.
Ah,
The balance you're asking about is what's in those accounts now.
yes, yes,
Okay.
I apologize. So let me go back then.
Okay.
At that time, when the transfer was made, you're saying there was approximately about 4,000 in there?
There was approximately $4,800 in the 2923 account and $466 and change in the account ending in 1712.
Okay,
That was after the wires. The balance that you asked about is today's balance, and that total for those two accounts is $11,278.55.
okay, perfect. So let's now go back to the accounts that you have. Those are Wells Fargo accounts?
Yes.
And whose name is that account in?
The personal, one of the accounts is personal account, is in my name and my wife's name.
At the time that the wires, the first wire came in, what was the balance in that account?
It was $12 and change, if I'm correct. It was a dormant account. We really didn't use anything. There were a couple of drafts, and so I transferred money in as I needed to cover the drafts, but we really didn't use that account. So that's why I segregated it for Courtney.
So the three balances that were transferred in that you mentioned, it totals $1,184,000. Is that
Yes,
accurate?
That's accurate.
Yesterday, the detective testified to believing over $2 million was transferred or belonged to Ms. Clenney. Do you have any information that there was over $2 million?
No, he was incorrect.
And how do you know that it was $1,184,000
Because
only?
I did all the transfers, and I was the only one accessing the account, and I have the bank records.
Now,
From both banks, by the way.
let's talk about the expenditures that were made
Okay.
from that $1,184,000. I know there's many, but let's just start with, let's say, the first big expenditure that was done.
Right. So one reason why I wanted to take control of the account, because I needed the CPA to finish her income taxes. And so that was the first big expense. And I got a cashier's check. I was the purchaser, but she was the remitter. And it was for $335,818.
And Judge, I would refer you to Defense Exhibit O, which is a cashier's check in $305,818 to the IRS. On this check, who is the purchaser of the cashier's check?
I was the purchaser,
And who is the remitter?
Courtney Clenney.
And why did you make Courtney Clenney the remitter?
It was her funds.
Let's talk about the next big expense.
Okay. The next big expense, she wanted to move home, put down roots again, be close to us again. So she decided to buy a house.
Okay.
And
And this house is located close to you?
she had a contract on the other side of town, and then another house came available closer to us, and so then she put an offer on that house.
And how much was the purchase price of the home?
And the purchase price was $1.35 million.
And what was the amount that was paid into as far as closing costs and escrow?
Look at my notes.
Yeah, please.
I know the number, but the first check on May 17th was for $21,000, and that was $20,000 escrow for their first house and a $1,000 non-refundable option fee. Then and I was the purchaser, but she was the remitter, and there's copies of cashier's checks, so I know that to be accurate. The second cashier's check was for $10,000 additional when she put the offer on the new house, and so the $20,000 for the first house was transferred over, so she had $30,000 escrow. The $10,000 was a cashier's check purchased on May 24th of this year. Again, she was the remitter, and I was the purchaser.
Okay. And how much was paid into the home?
At closing, again, I went to the Wells Fargo and got a cashier's check on dated June 16th. It was for $356,226.45. Again, I was the purchaser and she was the remitter.
And Judge, at this time, I would refer the court to Defendant Exhibit N, which are two checks, one for $21,000 and one for $10,000, and a additional exhibit for a cashier's check in the amount of $356,226.45. Let me ask you this. What makes you qualified to handle the finances of Courtney?
I have a finance degree, and I spent 15 years as an investment advisor.
Now, you said this account was yours. You didn't use it much, but did you mix your money with Courtney's money?
It was in the same account, but I segregated it on the ledger that I kept. I would print out the bank statements each month, and if there was anything that came out like a bank draft for my purposes, I would true it up so her money was always what it should be.
And how did you distinguish her money, when you say true up, how did you distinguish her money from your money?
I would go in and add each month if there were any, there was a loan payment that came out of that account.
I'm sorry.
There was a loan payment for me that came out of that account, and so at the end of the month, I would make sure what was attributable to me, I added up, and then I would either add back in to her money, or I would have to deduct it if she owed me anything.
Were there any costs associated with Courtney moving from Miami back home to Texas?
Yes.
Can you describe that?
Now, going this again?
Yes.
There were two major expenditures, but there were multiple expenditures in those two areas. The first was moving out of the condo, the liquidated rent, cleaning, painting, things like that for the condo, attorney's fees. That was $26,885. And then there was reimbursement.
I'm sorry, can you say the exact amount again?
$26,885. And then there was reimbursement to me for hotels and travel as far as, movers, rental for the truck, things like that. That was $30,074.
Okay. Now, did a large portion of the funds belonging to Courtney go to her defense of this case?
Yes.
She also went to rehab at some point?
Yes.
And how much was that?
The airfare and the rehab itself totaled $35,497.
Now, I'm sure that's not all the expenditures. Can you just give a general description of some of the other items?
There was $15,702 that went to some mortgage payments for the new house. There was Then she bought some assorted furniture, $12,072. And then there were some significant veterinarian bills, and that was $5,008. And beyond that, then you have the normal living expenses, daily living expenses, and then normal household expenses, electricity, utilities, things like that.
Now, at some point, a second Wells Fargo account was opened. It's ending in 4557. Can you explain what the purpose of opening that account was for?
Yes. So when Courtney was going to go to Hawaii for rehab, and so she was using my wife's debit card. So if we went to go get expenses for her that were related strictly for her, we would use a debit card related to that account, so we were using her money. When she went to Hawaii, she was concerned if she lost a debit card or somebody took it, she was concerned about the bulk of her money being in the first Wells Fargo account. So she asked me, Dad, can you transfer it? Well, I didn't really want to transfer it to another one of my accounts, so I opened a Prime account at Wells Fargo and transferred the bulk of the money over there, and that way, if she needed it, I could transfer it back in, which I subsequently did.
Now, was that Prime account, though, in Courtney's name or in your name?
It was in my name only.
Was any of the money in that Prime account belong to you?
No, it was a brand new account. I never put any mine in there.
And what is the balance in that second account, the 4557 account, as of today?
The Prime account, zero.
And how do you know it's zero? When's the last time you checked the balance?
Yesterday.
And what is the balance in the 4926 account? That's the other Wells Fargo
I have
account.
to look at my note. And this is as of yesterday, $126.65.
Okay. And so adding that to the two Bank of America account balances that Courtney has, it appears to be $11,405.20 total.
That sounds correct.
Okay. Do you have any knowledge of any other assets that Courtney has, such as stocks or bonds, other homes, boats, cars?
She has nothing other than the house.
And obviously she has equity in that home. She just purchased it.
Correct.
How much equity, if you have an estimate?
$350,000 to $375,000.
So as far as cash value, to your knowledge, Courtney has $11,400.
That's correct.
Okay. May I have a moment, Judge? I have nothing further. Pass the witness.
Good afternoon.
Hello?
So you've told us that you are Miss Clenney's father.
That's
right?
correct.
And obviously you have a very familial relationship with her. You don't want to see anything bad happen to her.
That's correct.
You would do anything for her, as well as look over her finances, but if it came to it, you would lie for her.
No, I would not. And I resent that accusation.
That's not an accusation.
It is an accusation.
I'm not trying to...
And I don't even lie. True.
Certainly. But my question to you is, if it came to it, would you lie for your daughter?
No.
Okay. And in regards to her working situation, you know that she worked for OnlyFans.
I didn't know that for quite a while.
You know that now.
I did.
You know that because you're in charge of her finances.
Correct.
And you actually just said that you were talking about the first charge, the first expenditure, you did her taxes for her.
Yeah. Well, I didn't do the taxes. The CPA did the taxes.
You collected the documents to give to him?
Correct.
Okay. So, in regards to OnlyFans, that's something that can be done online.
Yes.
And that's a job that can be, if you have any internet access, it can be completed from that internet access.
That would be true if it wasn't canceled by OnlyFans.
Well, my question to you though is, as a result of how the company actually works, if you have an internet connection, you could theoretically use it.
I don't know how the company works, I just know that they are on the internet. That's all I know about OnlyFans.
You know that her videos are online?
I do.
Okay. She's not working now, obviously.
That's correct.
But if she got out, there's nothing stopping her for trying to continue to work for OnlyFans.
They've canceled her account.
Correct. Right now. But nothing stops her from trying to reestablish that.
Well, I was told by her manager that they weren't going to open her account.
So I want to talk to you about the transfers themselves, but I want to start with, there's a letter that's in evidence that you wrote to the complex that she was living at down here in Miami.
Right,
That's dated, I believe, April 28th.
probably.
Was Courtney already out of Miami by that time?
Yes.
Do you know when she had moved back to, and I'm suggesting now, but you tell me, did she move back to Texas?
Yes.
She moved in with you.
Yes.
And prior to her going to the rehab center in Hawaii, she was living with you.
Yes.
In regards to those transfers that were done, first, the two that were done on April 12th, and two separate transfers, and then on May 3rd, did she do those transfers herself?
No, I did them.
You did them for her.
Yes.
Did she know that you were doing them?
Yes, she did.
And you told us already that you have a finance degree and you were working 15 years as an investment advisor, right?
Correct.
So you know the importance of keeping accurate records.
I did.
You also know the importance of, in wires, labeling what the purpose of them are for. Is that correct?
Well, I don't think I labeled them.
You don't think you labeled them?
I don't recall labeling them.
If I showed you the transfers, would it refresh your recollection?
Sure.
Your Honor, permission to approach? Mr. Clenney, I'm directing you to these transfers. Are you able to see what they are labeled under the section origin to BENE INSTR? Right.
Repayment of loans.
And so you see that you've labeled all three of them repayment of loans.
It was just an error.
So, sir, you say it's an error, but now you've also told us that it's important to keep accurate documents. Is that right?
Correct.
So now what you've told us today is, you know, the purpose of this was for you to be in charge of her finances.
Correct.
However, back on that day, you labeled those wires repayment of loans.
Right. Well, some of them were going to be all total repayment of loans, but then she needed money.
That doesn't answer my question, sir. You've labeled them two different things, one different here, one different on the day you made the transfers.
Right.
Are you lying then or are you lying now?
I'm not lying. It was an error on my part.
And now I want to talk to you about the defendant in her time in living with you. So during her teen years, did she live with you?
Yes.
Were there any incidents where either she was a danger to herself or to your family?
No.
Is there anything, so do you have any memory of any incidents of you being called out to a scene?
Judge, objection, this is beyond the scope.
Phase 2.
May we go sidebar?
So, Mr. Clenney, if given the opportunity that your daughter is released, would she come back to live with you?
That's an option, yes.
And do you find her to be a danger to you?
Absolutely not.
Do you find her to be a danger to your daughter, your other daughter,
No.
or your
No.
wife?
No.
And are there any situations that you've had between, or that you've seen, that you've observed or been privy to between Ms. Clenney and your wife and your other daughter?
I think, well, no, because I think there may have been an incident that I wasn't there. So
Did you eventually learn of what happened?
I think the sheriff's office may have been called, but she wasn't a danger to those two people.
Do you know why nothing was done further?
Judge, I'm going to object.
And now you've been in the courtroom for at least the first day of this hearing, right?
Correct.
So you've seen or at least heard a lot of the state's allegations against your daughter.
Quite
And
a few.
just, I'm sorry?
Quite a few, yes.
And in regards to the timeline that the state has presented as to a number of these allegations, do you still feel comfortable that you can control her if she was left in, I guess, your custody or in your control?
Could you specify which allegations? Or
Sure.
just in general?
Yes, Judge, if I could have one moment. So, Mr.
Judge,
Clenney?
I'm going to object beyond the scope of direct.
I think that, all right, I'm gonna rule it right now, let's see how far we go with this.
So, Mr. Clenney, in regards to the July 27th of 2021 incident in Vegas, you heard about that yesterday,
Not yesterday, the day before.
the day before. And then the text messages from October 9th through the 11th discussing your daughter stabbing the victim in the leg and then hitting
I
him in the...
don't think I know that to be true.
Well, whether you know it to be true, you were in the court and heard it.
I did hear it, yes.
And then also in January 30th through February 1st, the state's allegations that your daughter caused this injury to the victim, slicing him to the
I
face.
did hear it. I did hear that.
And then the February 21st incident in the elevator.
Well, it's obviously she's under duress, and we don't know what happened before or after.
Well, my question to you is, you heard about it yesterday,
I heard about it the day before yesterday.
the day before yesterday. And then in regards to March, the multiple conversations between your daughter and the defendant where she calls him a number of different names. You heard about that yesterday.
I did hear about that, but I don't know in what context.
Certainly, I'm not asking you that. So, and then obviously the incident that took place, the date of the incident, when the defendant killed the victim. You heard about that 2 days ago.
Well, when the defendant acted in self-defense, I heard about that, yes.
So, after hearing those incidents that the state has brought to your attention in the last 2 days, you still feel comfortable allowing her to come home to your house, that you believe you can control her?
1,000%,
Okay.
no doubt.
One moment, Your Honor. Judge, I have no further questions. I would just move in those two documents.
Thank you. Mr. Clenney, are you aware of any banking regulations that say that you must, in the memo line, put exactly what a transfer is for?
I'm not aware of any.
And you testified that it was an error by putting in the memo line that it was a payment of a loan?
Right, so if I put that in there, there was a sizable loan to Courtney, and that would have been repayment, but one of those wouldn't have covered that. So that's why I've been on the larger. If I'd had any notes to that, that's why that would have been put there, but I don't recall that.
The money that was transferred into that account from Courtney, whose money does that belong to?
That's Courtney's money, and I've spent it all on her behalf.
And did you do it with her permission?
Yes.
Now, the state attorney said, you know, you've been sitting here in this courtroom on the other day, you've heard all these allegations that were made, and he asked you if you feel comfortable having Courtney come home with you. Is that right?
I do,
And why do you feel comfortable?
because I've lived with her a number of years growing up, and she was there 2 to 3 months with us this year. So I have no doubt that there wasn't any problems. I have no concern about that.
And did you have knowledge of the true relationship between Courtney and Ablamoseli?
Oh, yes.
And what was that?
Objection, Judge, as to relevance.
He opened the door, Judge.
Yes. It was very toxic. And I knew from the beginning that he was not treating her correctly. I saw proof with my own eyes. I heard calls between them, calls to my wife. I heard many things that a father who loves his daughter very deeply should never have to put up with. So, if she didn't deserve what she put up with.
Thank you. I have no further questions.
Judge, I would just ask that those two documents, if we have a ruling as to, at least for purposes of impeachment at this point.
While they won't, evidence isn't, impeachment isn't going to be the evidence, but, have you had a chance to look at the documents?
May I ask which documents, Your Honor?
It's up to you.
No objection, Judge.
Yes, Judge. And Judge, for the record, that would be states 1L for identification purposes, as well as states 1K for identification purposes. No, they're not going to come in.
1L will become State Exhibit 11. 1K will become State Exhibit 12.
So, I think that we can go ahead and proceed with the medical examiner testimony.
I believe so, Judge. So the state would call Dr. Hutchins to the stand. We're just going to keep that out. Do you want to put that to the side? Okay. I hate how we do that.
Judge, I have this copy just for the clerk, and you want to keep the other copy? Okay.
Here, come up for just a moment. I don't think it's sidebar, she's not very, exhibits. You guys will go to the microphones. George is saying that I think maybe the defense exhibits weren't labeled on Tuesday.
Oh,
So let's just make sure that all of the exhibits are labeled.
I don't know what,
Defense exhibit label. The only one I have labeled are the ones you gave me today.
I don't know what I am.
Oh.
ABC and D.
Yeah, so,
I have nothing else labeled.
so this
And
was,
you guys are
this,
referring
this was dropped off to the, because we didn't have a package for the clerk on Tuesday. And we dropped them off that next day, the next morning at the clerk's office. So during the hearing, they were not being labeled by the clerk because we had forgot to bring a copy. But they,
These are,
that was the list at that time, correct?
okay, and that's what you're going by when you're saying A, O, O, N, whatever?
Correct. And the supplemental exhibit list was filed this morning. later this week.
Is this something I have to change the numbers on these? I don't need that right now, right?
Correct, we do not.
Okay, so let me tax what we do.
Yeah.
Yeah, we can.
And I
In the
think we
break,
should
we
have
also-
our exhibit labels on them, and,
Yeah, but I have to do that.
of course, but those are correct, yeah. Even though we supplemented, it's just that there's gonna be more.
You swear or affirm the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Good afternoon, Dr. Hutchins.
Afternoon.
Thank you for coming back today. If you could please introduce yourself to the court.
My name's Kenneth Hutchins. I'm the Chief Medical Examiner for the Miami-Dade County Medical Examining Department.
And just for the record, are we able to hear him?
Yeah, hello.
Okay. So, Dr. Hutchins, where are you currently employed and what is your current position?
I'm employed by the Miami-Dade County Medical Examiner Department, and I'm currently the Chief Medical Examiner.
And how long have you been working there?
About 21 years.
And how long have you been the chief medical examiner?
A little over 1 year.
And so were you in that position at the time of this case coming in?
Yes.
Now, is this your office? Is it an accredited office?
Yes.
And what does it mean to be an accredited medical examiner's office?
It means that we have standards that we meet for the National Association of Medical Examiners.
And could you please explain to the court some of your background in becoming a medical examiner?
I received my BA in biology from Swarthmore College, my MD from the University of Pennsylvania School of Medicine. I did a pathology residency and neuropathology fellowship at the Albert Einstein College of Medicine in New York. I did my forensic pathology fellowship and training at the Office of the Chief Medical Examiner in Baltimore.
Yes, Your Honor, we so stipulate.
So I'm going to bring you and your focus to this matter, to this case. And so the case, were you assigned to ME case number 2022-1069?
Yes.
And how exactly do you go about the process of being assigned a case?
I was likely scheduled to be in the autopsy room that day, and it was a case that I ended up doing.
And in regards to this matter on April 4th, did you come into contact of the body of Mr. Ambunselli?
Yes.
Person's approach, I'm showing you what's in evidence as States Exhibit 2. Do you recognize it?
Yes.
And who is that?
That's the decedent, Mr. Christian Ambunselli.
If you don't mind, can you please publish it to the court? Judge, if you don't mind, if you could just keep that up there. Thank you. One moment, Your Honor, I apologize. Just for the record, Judge, I'm showing defense the photographs. Now, Dr. Hutchins, when you were observing the body, were there any evidence of medical intervention?
Yes.
And what exactly was that?
I'd have to review the medical examiner report to let you know.
If you don't mind just taking a moment.
He had a lot of medical intervention, including an endotracheal tube protruding from his mouth, a catheter in his left groin, vascular catheter, a urinary catheter from his urethra, a 21-centimeter transversely oriented sutured left thoracotomy incision. The pericardial sac was open. The sac around the heart was open. There was 200 milliliters of blood in the left chest cavity. There's a chest tube protruding from the right chest. And he had multiple needle puncture marks on the upper aspect of the left chest associated with some subcutaneous hemorrhage.
And now in regards to the wound itself, Was it a singular wound?
Yes.
Now I'm showing you States Exhibit 3 and States Exhibit, I believe, 9. No, it's not going to be 9. States Exhibit 3 and States Exhibit 4. First, States Exhibit 3. Do you recognize this?
Yes.
What is this a photograph of?
This is a photograph of the sutured wound in the upper left chest.
And is it the same condition that you saw that day?
Yes.
Please publish it to the court. Now, at some point in time, did you remove the sutures?
Yes.
And what was the purpose of that?
To get a better idea of what the wound looked like.
I'm showing you States Exhibit 4. Am I taking a look at that? Is that how the wound looked after you removed the sutures?
Yes.
You could also publish that to the court. I'm also going to show you States Exhibit 6 as well as States Exhibit 5. Is this a closer, and that's States Exhibit 5, is that a closer image of that wound?
Yes.
And how exactly would you describe the wound?
It's a sharp force injury wound that has nice, clean, sharp margins. It's extended open. It was 4.4 centimeters in length with the sutures in it, and when the sutures are removed, it's 4 by 1.5 centimeters. There's a lot of hemorrhage beneath it, and there's no contusion or abrasion around it. So that suggests that it's a sharp force injury and not some other type of injury.
And is it consistent with what you would see with a knife injury?
Yes.
If you could also publish 5 and 6 to the court. Now, something that I do believe may come up by defense, are you a knife throwing expert?
No, I'm not.
Are you an expert of someone or what knives would do to people?
Yes, I am.
So, in regards to the wound itself, what type of injury did that knife wound lead to?
It went down into the soft tissue and through the muscle and injured the right subclavian artery.
And now I'm showing you States Exhibit 9. Do you recognize it?
Yes.
And what does this photograph show?
This photograph shows after the skin is removed from the where the injury is, the hemorrhage around the injury, and the injury in the right subclavian artery.
If you don't mind me, I'm going to hold it up for you. If you could point exactly to where the injury is for the court.
The artery is here, and the injury is right here in the artery.
If you could publish this to the court. And now I'm showing you States Exhibit 1. Do you recognize this?
Yes.
What is this?
This is a picture of the artery after I removed it from the body.
And I'm going to hold it up. If you could please explain to the court exactly what you can see from this photograph.
This is the inside of the artery after it's open, and there's a lot of hemorrhage around the injury in the artery.
If you could publish that, thank you. Now, Dr. Hutchins, if you could explain, was this a stab wound or an incision wound?
A stab wound.
And what are the differences?
Well, in general, an incised wound is longer on the skin than it goes into the body. A stab wound is measured shorter on the outside of the skin than it goes into the body.
And in regards to this wound specifically being a stab wound, how far into the body did it go?
Approximately 8 centimeters.
Now, when we talk about 8 centimeters, is that more than 3 inches?
Around that.
Can you explain to the court exactly what occurs when someone is stabbed in, say, specifically the subclavian artery?
Bleeding.
How do you stop the bleeding?
You'd have to go to a hospital and they would stop the bleeding. I don't really treat live people, so I can't be more specific than that, but you go to the hospital and they will treat you.
And so the importance is, if you're not able to stop it though, would you bleed out?
Yes,
And would you continue to bleed?
yes,
Can you die if you're not treated medically?
yes.
Now, could you explain exactly the location of the wound?
The wound is on the right side of the chest, 13 inches below the top of the head and 6 inches to the right of the midline of the front of the body.
And now this wound specifically, did it have to penetrate muscle?
Yes.
And how much force specifically would be needed to say, breaking the skin for a wound like this?
Well, people have done experiments to see how much force it takes for a knife to go into different parts of the body. If the point of the knife is sharp, it takes between 8 to 12 pounds to get through the skin.
And now, we had talked already about the sutures. Do the sutures, the fact that they added sutures to this wound, did that do anything to change the depth of this wound?
I honestly don't know what they did with this wound. If all they did was suture it, it would not change the depth of the wound, no.
And now this trajectory, in regards to the trajectory of this wound specifically, what is the trajectory?
It's front to back and slightly downward.
Is that consistent with the knife coming downwards?
Yes.
Now, there's a couple of other items I want to talk to you about that's a part of your report. Toxicology specifically that was done on the victim. Were there any substances present?
Yes.
What was present?
Cannabinoids.
Would that have any effect on the stab wound?
No.
In regards to, I think you also wrote in there something about cardiomegaly. Could you
Yes.
explain exactly about that exactly?
It's an enlarged heart. His heart was 470 grams, I believe. So it's an enlarged heart, but he was a big guy, and if you're a person that exercises a lot, you stimulate your heart and it can become large.
And would that have anything to do with this stab wound?
No.
Other than that, is the victim in good health?
Yes.
Now, what information were you provided in this case?
I was provided information from our investigations report, and we have a preliminary death investigation report for the medical examiner from the police as well.
If you don't mind informing the court, what information did you have in regards to how the victim received this wound?
I'd have to read the report.
Your Honor, do you have any issue if he reads from the report?
I'm sorry, I didn't. No objection.
Dr. Hutchins, you can read from the report if you'd like.
Okay, it's a very long report, but I'll just say, it says, the offender, in fear for her life, warned the victim to stay away. The victim approached in an aggressive manner. The offender threw the knife and struck the victim on the top right chest area. The offender then called police and attempted to add pressure to the wound.
Based on that information, I want to pose to you a couple of hypotheticals, but the first and the last thing I want to show, Exhibit 8. If you could explain to the court exactly what this is showing, I'll hold it up for you.
I put probes in the artery and the vein. The probe came out of the artery. The probe went through the vein, so the vein was intact.
Is that to show also the trajectory of the wound?
No, this doesn't show the trajectory of the wound. The wound is going downward and from front to back. I have these just going in the arteries. They're going laterally from left to right.
You can publish this to the court. Thank you. So going back to these hypotheticals, based on the information that you had in your observations, the position of the wound, the angle of the wound, the depth of the wound, does that support that the victim and the defendant were face to face when this happened?
As a hypothetical?
As a hypothetical.
Yes.
And as another hypothetical, based on the same position, observations, the angle, the depth, does it support that the victim was stabbed?
Yes.
Based on those same observations, does it support that at least 8 to 12 pounds of force would have been used in order to create that damage.
In general, yes.
And that damage being breaking through the skin, plunging the knife 3 inches into the victim's chest, and cutting through muscle, eventually the subclavian artery.
Yes.
Now, based on the information you received that the defendant was alleged to have thrown this knife, do your observations support that?
I'm not an expert in knife throwing. If the person who supposedly did this is an expert knife thrower, and the knife is the type of knife that you can throw, I guess that could have happened.
Did you receive any information that the defendant was a knife thrower?
No.
So based on that fact that you did not receive that information, would it support that?
No.
And what would you expect to see a knife do if someone just flung it at somebody?
Threw it the way a knife thrower throws it?
No, someone
Just-
that's not a knife thrower.
It would just hit the body and bounce off.
Now, as a result of this case, did you come to a cause, or did you make a determination as to the cause and manner of death?
Yes.
Could you please explain those to the court?
The cause of death was stab wound of right subclavian artery. The manner of death was homicide.
I have no further questions.
Good afternoon, doctor.
Afternoon.
Around what time did you receive the body for you to be able to perform your autopsy in this case?
Well, I performed the autopsy at 9:30 a.m. I'm not sure when the body came to our office. I'd have to look through the paperwork to see.
That's okay. And 9:30 a.m. on April 4th?
Yes.
2022?
Yes.
And you understand that this incident took place on April 3rd, the day before?
Yes.
Okay, so the very next morning you were already performing your autopsy?
Correct.
Okay. And prior to conducting your autopsy, you first read and review that preliminary police death investigation report for the medical examiner?
If we have it, I do, yes.
Okay, and it's fair to say that you might not always have that, right?
Correct.
And that's because you have to wait to receive it from the detective in a case?
Yes.
So having that or not having that, that doesn't really affect your ability to get started on doing your autopsy.
Not to get started, that's correct.
Do you know if in this case you had that report before you were able to start? Do you remember?
I don't have any independent recollection.
That's all right. So you start your autopsy at 9:30, and before we get to exactly what you performed, well, let me just say this. There's a lot of paperwork that goes into all that you do, right? It's not
Yes.
just all your examination.
Yes.
There is a release of the body, eventually an authorization for that, right?
Yes.
There are case notes that you do.
Yes.
There's a forensic evidence form,
Yes.
a death record, medical information sheet,
Yes.
a microscopic report.
Yes.
So lots of paperwork.
Yes.
All right. First, before we go into what you actually performed, I want to go over this preliminary police death investigation report that you eventually received. And this is, fair to say, a tool to help you put some context to the situation. Is that fair to say?
Sometimes, yes.
Because you clearly, obviously, you are not present for what happens that makes you receive the body, right?
Yes, that's correct.
In any case, not just this case.
That's correct.
So you have the autopsy you perform, but having some of the information, some of the background can be useful to you in making your final opinion. Is that right?
Yes.
Okay. And what you learned from this report was that according to what it says, that Ms. Clenney said she was arguing with the decedent, Abumseli, when he grabbed her by the neck and slammed her onto the wall. Is that right?
Yes.
She then says that he grabbed her, threw her on the ground, and held her down by the neck with both hands.
Yes.
Then, in fear for her life, she warned him to stay away. Is that right?
I don't have that in this report that I'm looking at, the police report.
If you look at the last paragraph, it says the offender in fear for her
Yes, I see
life.
it now. You're correct.
The victim approached in an aggressive manner, is that right?
Yes,
And that is important information for you, right? Whether the person was stationary or moving could make a difference to you, is that right?
it could, yes.
Okay. And we'll get more into that in a bit, but according to the report, the offender threw the knife and struck the decedent in the top right chest area, is that right?
Yes,
And it also said that she called police and attempted to put pressure on the wound, right?
yes,
And putting pressure on a wound could also make a difference as far as blood loss, right?
yes, it could.
And we'll talk about that in a few moments. Now, your opinion was that this was homicide, and you put that in various portions of your reports, is that right?
Yes,
You would agree with me that a homicide could be justified, right?
yes.
Now, what happens in a situation if after your report or your autopsy, you determine that you do believe it was in self-defense? Is there a way that you document that on your reports?
That's a legal thing. We don't have anything to do with that.
Okay, so even if you felt it was justified, you wouldn't write down homicide justified?
Correct,
You would just write homicide no matter what?
correct.
Okay. I'd like to talk about the social history. These are in the case notes, and I understand there was a Carlos Marmolejo that took the case notes. Is that somebody that works for your office, sir?
Yes, it is. He's a medical legal death investigator.
Okay, perfect. And that is somebody who will sometimes be in contact with the families?
Yes,
And in this case, they spoke with, according to the case notes, the aunt of Abum Seli in order to get some information. Is that right?
yes,
And some of that information could be useful to you, obviously, whether the person is healthy or not healthy, has a medical history, illnesses, that sort of thing, right?
yes,
And one of the things that your office was advised was that he did not drink, smoke, or use illegal drugs. Is that correct?
yes, that's correct.
But in fact, when the toxicology came out, it was detected that he tested positive for marijuana. Is that correct?
Yes,
And I know that you're not the toxicologist that performed it, but as the chief medical examiner, you do review that toxicology and you sign off. Is that right?
correct.
Let's talk about the estimation on time of death. Is it fair to say that you cannot with certainty state when the stab wound occurred in this case?
That's correct.
And obviously, one, you've already said you weren't present, right?
Yes,
But it's also very difficult because there are many variables that go into that. Is that right?
yes, that's true.
So, for example, as somebody is losing a lot of blood, it will have different physical effects on a person's body, correct?
Yes,
So, in this case, the subclavian artery was hit. That is something that's going to lose a lot of blood, right?
yes,
And so when a person is losing a lot of blood, the various physical effects they may feel could be chills, right? They get cold,
they could, yes,
loss of feeling in their limbs.
yes,
They might have problems speaking
as they start to go into shock, maybe, yes,
and then lose consciousness.
yes,
And the rate of loss of blood can be affected by, for example, how big the person, their body type, right?
it could be, yes,
What about if pressure was placed on the wound versus not placed on the wound?
yes, that could affect the amount of blood that is lost.
And the usual progression of blood loss will be that the person might be speaking, then move to nonsensical speaking, then kind of just making kind of noises until they lose consciousness. Is that right?
That could be something that could occur, yes.
Now, did you listen to the 911 call in this case?
No.
Okay, are you aware that Mr. Albumselli, first of all, 911 was called at 4:58 p.m. Are you aware of that?
No.
Okay, and were you told by anybody that when 911 was called, he could be heard saying, "I can't feel my arms"?
No.
Okay. If you heard, though, or you understood that information, that would appear that he wasn't at the point where he was at unconsciousness yet, correct?
That's correct.
Now, in this case, you did receive information that time of death was called at 5:58 p.m. Is that right?
I have it at 5:55 p.m.
You're correct. I apologize. 5:55 p.m.
Yes.
That the 911 was called at 4:58, and approximately 1 hour later is when time of death was called. Is that right?
Yes.
I'd like to look to your autopsy protocol and dictation. This is really the substance of your examination, right? Your report?
Yes.
And the first thing you do is you conduct an external examination of the body?
Yes.
And I understand here you had put no fractures, lacerations, or deformities of the extremities. Let me ask you this. Can you explain what the difference between a stab wound and a laceration is?
A laceration is a tear in the skin from a blunt force injury. So a blunt object hits the skin, it tears the skin. So when you look at the injury, there might be an abrasion or contusion around it because the skin was struck by a blunt object. It tears the skin, so you have tissue bridging going from one part of the skin to the other. These are small vessels that don't get torn when the blunt object strikes the skin. A sharp force injury cuts the skin. You don't get abrasion or contusion around it, and you don't have tissue bridging because those little vessels are cut.
Okay, so that's the difference of why you wouldn't call the stab wound to the chest a laceration?
Correct.
Okay. You did notice, though, that there was a healing scar surrounded by smaller healing scars on the right heel. Is that right?
Yes.
Okay. And the heel is considered the foot?
Yes.
Okay. You didn't notice any healing scars on legs, did you?
Legs, no.
And you didn't notice any lacerations on the legs, is that right?
That's correct.
If you had, you would have documented, right? That's what this portion of your report is for?
Yes.
Okay. Now, the internal examination, I am sorry I didn't understand half of what you said of all the things you did. Obviously, I'm not a doctor, but there's a lot of things you have to do, right? You have to weigh the lungs and the spleens, and you do all these different tests. Is that right?
Yes.
Okay. And that's just normal protocol in any of these cases?
Yes.
And you do that because obviously you want to make sure you do everything you possibly can in order to make a proper determination as to cause of death?
Yes.
Now, your opinion in this case was that the wound was not caused by the throwing of a knife, correct?
I'm not an expert in knife throwing. I don't know whether the person who's charged with this is a knife thrower. As a hypothetical, my opinion is it was a stab wound. But if you give me other information that the person is a knife thrower, they throw knives and they throw them into targets and whatnot, then maybe this could have been a knife that was thrown.
Okay. Okay, well, we're gonna break that down. Before we do, I wanna ask you a couple of things. I know that you eventually, you did review this preliminary report, you said. Were there any other, reports that you reviewed in this case? For example, the fire rescue report?
No, not that I recall.
Okay. Any other supplemental reports from the detective?
No,
Did you review Ms. Clenney's statement to the police?
no,
Would you agree that perhaps there could have been something in her statement, facts, important facts, that could maybe change your determination as to the outcome?
as the cause and manner of death?
As to, not the cause of the death, but as to that it wasn't by a knife being thrown?
Repeat the question again?
Is it possible that by reviewing her statement completely, it could possibly have changed your determination that a knife could not have been thrown in this case?
It could have, yes.
So let's look to the evidence of the injury. That is another section in your report, right?
Yes,
Okay. And first of all, when you received the body, the wound was sutured, right?
yes,
And that's just normal because when the person goes to the hospital will do that and give it to you, or not necessarily?
not necessarily.
Okay. Is it fair to say by suturing it, it might change how you can observe the body in its, I guess, most natural form of when the incident occurred?
That's fair to say, yes.
And you don't know if, you weren't there, so you don't know what fire rescue personnel might have done. Paramedics did for life-saving techniques, right?
That's correct.
And you don't know what kind of life-saving techniques the doctors at the hospital performed either, right?
That's correct.
So you received the body, you removed the sutures, and then you observed the stab wound, which I believe in your report and you testified is 4 by 1.5 centimeters, correct?
When I remove the sutures, yes.
Yes, and again, when you remove the sutures, we don't know if that wound is the same wound I don't mean the same wound, I mean, we don't know if it's the same size as when the stabbing originally occurred, right?
I don't know if the hospital physicians did something to the wound. That's correct.
Okay, and 4 by 1.5 centimeters, that would be equivalent to 1.5 inches by 1/2 inch? I did the mathematics. I'm just not a centimeter person, so I
Yeah.
put it into inches.
I think an inch is like 2.5 centimeters. So you're talking more about 3 inches
Okay,
in length,
okay.
or 2 inches in length.
Well, the 8 centimeters, which is the depth of the wound, is 3 inches. So would you agree that the 4 centimeters is gonna be
It's
half of
shorter.
that?
That's correct.
So 1.5 inches?
Probably, yeah.
Okay.
I'd have to do the math.
I understand. And according to your report, you put that the wound, that it was a slightly downward angle, is that right?
Yes.
Now, I looked up the definition of slightly in the dictionary, but is there a medical term for slightly?
No.
Okay, so I got small or inconsequential. Does that sound fair to say to you?
It just went down a little bit.
Just a little bit. And do you ever give percentages, or
No.
that's not something?
No.
Okay, so you can't tell us exactly, I'm gonna say this in this downward angle. It's not a downward angle like this, right?
Yes, that's
When
correct.
you say slightly, if we're taking something, it's gonna be just a slight angle.
Yes.
Okay. Now, do you agree that when a person, if somebody were standing face to face and stabbing somebody, would you agree that it would depend on the height of the individuals, of the two people?
The injury?
Well, potentially, how slight it goes in. It could be based upon the entry wound could depend upon the height differences of the two people.
When I describe wounds on the body, we're looking at the body in anatomic position, lying on the autopsy table. When something happens to a person, if they're shot or stabbed or beat, they don't stay in anatomic position. They move. So I can't tell you in what position the person during the stabbing was in and in what position the person being stabbed was in. They could have been bending over, they could have been bending back, they could have been on their knees. I don't know.
Okay, that's fair to say. So it would be clear that you don't know if, for example, Abumseli was leaning forward and going to aggressively attack Ms. Clenney, right?
That's correct.
Which would then move his body forward and could affect the angle of how a knife goes into his body.
That's correct.
Also, the fact that she's 5'8" and he's 6 foot, which is a 4-inch difference, that's not something you're taking into consideration in your examination.
That's correct.
Now, the location of the wound was the upper chest right side.
Yes.
And that, fair to say, like near the shoulder?
Yes.
Okay, and for the record, I'm pointing to my shoulder area on the right side. You noted that it was a front to back, which just means from the front of the person going inward towards the back, is
Yes.
that right? Okay. Now, and I'm assuming this is because of the anatomical position of the body, but you didn't mention if it was like at an angle, coming crosswise, or straight on. Was it straight on?
It was straight on, yes.
Okay, so if hypothetically Courtney is right-handed and the wound is on the right side and she did stab him versus throwing the knife, she would have had to have been offset from him to be able to put the knife straight into his right side, right?
It depends on how he's standing. If he's just standing in anatomic position, yes. If he's moving, I cannot tell you in what position the person who was stabbed was in or what position the person who was doing the stabbing was in. I can just tell you what I see on the body.
Okay. And in your report, you document that the wound is approximately 8 centimeters, which we said was 3 inches, right?
Yes.
It's about 3 inches. You understand that the knife was removed before the paramedics arrived? Did you know that information?
I didn't know that information. I did see a picture of the knife.
Okay. And let me ask you this, because if a person were to, and the testimony from Courtney was that Abumseli removed the knife himself. If a person is in shock from having been stabbed and they go to grab the knife, it is possible that the knife could be pushed in a little further. Would you agree with me?
I'd agree with that, yes.
And it would be impossible to know exactly, I mean, you couldn't give a certainty as to how much exactly it could be pushed in, right?
I can't know.
And obviously, if the knife is in and you pull it out and it was in an artery, blood is going to really start coming out, right?
Yes.
Okay. Now, you mentioned that the pressure used to have the force to put a knife into a body would be 8 to 12 pounds to get through the skin. Is that a fair statement of your testimony on direct?
People have done experiments on cadavers, putting knives through different parts of the body, cartilage, bone, skin, and they have described it as being 7 point something to 11.9 pounds to go through the skin. So 8 to 12, yes.
Now, knowing that this was in the subclavian artery, it didn't go through bone?
No.
Okay, so it went through muscle and then the artery is right underneath the muscle?
Subcutaneous tissue, muscle, and then the artery is down there, yes.
Okay, so you're not sure exactly how much pressure, but estimating based upon experiments, you think approximately 8 to 12 pounds.
Yes.
Now, that's quite a bit of pressure. Would you agree with that? That's not just like me standing here and just like straight putting a knife into somebody's body, right? You have to
You have
really
to push
put
it
some
in.
pressure.
Yes.
Okay. And would you agree with me that it would be more the pressure, the more you can move your hand back and move something, you're going to get more force to it, right? Just like a baseball, if I'm throwing a ball, I'm going to get more pressure and it's going to fly farther than if I just hold it like this and just kind of throw it like that, right?
That's correct.
Okay. So, did you see any defensive wounds on Mr. Abumseli?
No.
All right. Now, let me ask you this. On the autopsy dictation, if you want to refer to that, sir, it has height and weight. Can you tell me, with your handwriting, I apologize, the weight, what does that say, sir?
Which form are you looking at?
It's called the autopsy dictation. If you
Oh,
don't,
yeah.
you have it?
200.
Okay. That's a 2, that's a 0 and a 0. It looks like
Yes.
a 2.6.
No, it's 200.
Okay, and what's the 2.7 underneath it?
Is BMI.
BMI, okay. So 200. And if I told you that Courtney was 150, then the decedent Abumseli had 50 pounds on her. Is
Yes.
that right?
Yes.
And 4 inches.
Yes.
And as you say, like, having to go back and pressure and everything like that, you didn't see anything from Abumseli of putting his hands up or anything like that?
I didn't see any defensive injuries on his arms or hands, no.
Okay. You would agree that somebody who is 6 foot tall has a farther reach than somebody who is 5'8"?
Depending on the length of their arms, yes.
Okay. Now, would you agree that it's also possible to, for somebody stabbing somebody, they could possibly have self-inflicted wounds? Isn't that possible?
Yes.
And that's because I think they call it slippage, right? Because of so much blood, the knife could slide back and it could cause cuts on the person's hand, right?
Yes.
Okay. I'm sorry. Judge, if I can have a moment. I'm showing you Defendant's Exhibit S. Sir, can you see that? All right, these hands?
Yes.
Okay, and were you able to see crime scene photos in this case? Were you able to observe did they give you the crime scene photos to look at?
I did see some crime scene photos, yes.
Okay, so this is a photo of Miss Clenney's hands on the date of the incident. She didn't have any kind of self-inflicted injuries from a knife that you can see. Is that fair to say? And I can have a photo come closer to you if it's easier for you, sir.
I'd like to see a closer
Yes,
photo.
let me, do you have S? Yeah, the ones from, yeah, thank you. Having reviewed the photographs, were you able to see any wounds on her that would be consistent with slippage of a knife?
No.
You can, hold on, just wait 1 second. Oh, can you turn to the next one, please? Oh, here. Thank you. Now, you received photos of the knife. I think you said you
I
saw
saw
them.
photos of the knife, yes.
Okay. And from your examination of the wound, would you be able to say how sharp the knife was?
By just looking at the wound?
Yes.
No.
What about, you see this knife, this kitchen knife, can you tell how thin or thick the knife is by your examination?
By looking at the wound itself?
By looking at the wound, yes, sir?
No.
And what about by examining the knife itself?
Are you getting at whether I can tell whether that was the knife that did this particular thing?
Well, let's assume it is.
Okay.
I don't think there's any a disagreement with that. So my question would be, if you had the knife to examine, would that help you in determining whether it is thin or thick or sharp
Yes.
or dull? Now, you would agree that a knife that is thin is able to penetrate deeper into a body than one that is dull, right?
One that is sharp would be...
Yes, one that is sharp,
Yes.
excuse me.
Yes.
But not just sharp, one that is thin versus thicker is what my question really was.
Well, it depends on how sharp the knife is, not
Okay.
necessarily thin or thick.
Now, in this case, this is the Global Cromova stainless steel knife, GS14. It's a very sharp and thin knife. Did you do any research into this knife before
No.
you made your determination?
No.
Did you get any information on the weight of the knife?
No.
You do understand that the weight of a knife can make a difference when it is thrown through the air, right?
I'm not an expert in knife throwing.
Are you aware that the distribution of the weight can make a difference on the rotation of the knife in the air as it is thrown?
As a novice in this particular thing, I would be aware of that, yes.
Okay. And are you aware the more a knife weighs, the deeper it can penetrate a body?
When throwing it,
Yes, sir.
that I don't know.
Would you agree with me that throwing a knife into a stationary object could be different than throwing a knife into a moving object?
Yes.
And that's because a knife throwing has velocity, and a person moving in that same direction has a certain velocity as well, right?
Yes.
And you were made aware that Abumseli aggressively moved towards Courtney at the time. She states she threw the knife, right?
That's the information that I have, yes.
You understand that a knife gains speed as it travels?
That I don't know.
Distance is important in a knife being thrown?
As a novice, that probably is correct, but I want to say again, I'm not an expert in knife throwing.
Okay.
I am an expert in what knives do to people.
All right. But having said that, your opinion is that Courtney could not have thrown this knife, right?
As a hypothetical, the hypothetical that I was given, I said that what I see on the body is consistent with the person being stabbed. If I get other information that the person doing that had the knife is a knife thrower, that this is the type of knife that you could throw and it will go into a target, then I might have another opinion.
Well, you're saying knife thrower, but a person doesn't have to be an expert knife thrower to actually hit a target. Isn't that true?
That I don't know.
Have you seen there are millions of YouTube videos out there with people who are knife throwing and they're not experts?
I don't watch YouTube.
Did you consult with a knife throwing expert?
No, I did not.
did you do any research into knife throwing?
No, I did not.
Have you written any kind of articles or published anything regarding knife throwing?
No, I have not.
You agree that a person could generate a lot of power in a throw based on adrenaline?
Judge, all this is speculation.
He's an expert, Judge. Well, the government's opinion is that she couldn't have thrown it, so we should be able to rebut that opinion by asking him questions about it. They put that into evidence. So, sir, you cannot say that Courtney Clenney did not throw this knife, can you?
That's correct.
And your autopsy was performed on April 4th, and I know the toxicology was signed off on May 2nd. Is that correct?
Yes.
When did you speak to the state attorney's office and let them know what your opinion was, if you recall?
I spoke to someone in the state attorney's office in June of this year, end of June, I believe, and I also spoke to someone in the state attorney's office last week or the week before.
Okay, so before June, though, was there anything more to your report other than after May 2nd when you signed off on the toxicology? Anything else you needed to perform to close out your portion of the case?
No.
Okay, so as of May 2nd, you had your opinion. On the end of June, you spoke to the state attorney's office?
Yes.
Okay, and the charges here were filed, you're aware, in the middle of August?
I don't know.
Okay, may I have a moment? Sir, all your testimony, your conclusions, they're all documented in your report, is that correct?
In the autopsy report?
Yes, you've documented all of your conclusions in your report.
I documented the autopsy in the report,
Okay.
yes.
I noticed that there's nowhere in your report that says your opinion on the hypothetical was that the knife couldn't have been thrown. Is that something that would go into a report?
No, it would not.
It would not, and there's no reason for you to file any kind of supplemental report in
That's
this
correct.
case? Okay.
This report has cause of death. The death certificate has cause and manner of death. If you have other information that, I don't have anything to do with, whether it's a death that is a justified homicide or not justified, that's a legal thing. I just know the cause of death is stab wound of right subclavian artery. The manner of death is homicide.
Understood. Thank you, sir, for your time.
Yes, sir, just briefly. All right, so Dr. Hutchins, the defendant gave a statement in this case, and if she was to tell you, and this hypothetical was posed to you, that she's 10 feet away, so roughly as far as I am from you, and she used the word flung the knife, and you weren't provided any further information that she was a knife-throwing expert, is it your opinion that she could not have thrown the knife?
She said she flung it.
Flung it.
I would say that that is not something that could have happened given the injury that this person has.
No further questions, Judge.
Any other speaks?
From the state, yes.
Yes.
Nothing from the state.
Nothing from the defense.
The state's going to rest.
Yes, Your Honor.
So, let's go ahead with the three closing arguments. Let's start with phase one.
Yes, Judge. And, Your Honor, we are still doing the pretrial detention at the same time, so I'll address both. So, Judge, the burden for the state is proof evident. The presumption is great that the defendant committed this crime. That is all evidence and all inferences created by that evidence is to be viewed in the light most favorable to the state. So when you hear the evidence from the ME that he says that her story doesn't match, that it doesn't scientifically work, the inference is that when she gives that statement, she's lying, and she's not telling the truth. And that is the inference that now is put in favor of the state. When the other inference, when the state puts forward evidence that she's on the phone with her mom when the incident takes place, and then we put forward the mother's statement that doesn't include any of the events that the mother should have heard, the inference is the mother is lying when she speaks to police and is withholding information. The inference from that is that she's trying to assist her daughter. So, in the light most favorable to the state has moved a number of items of evidence before Your Honor that shows that this defendant has committed this crime. And obviously the pretrial detention motion, it's a substantial probability, it's a lower burden. So if we are meeting Arthur, then we are meeting substantial probability. And I want to go a little bit through some of the things of the defendant's statement. First and foremost, I need to inform the court that the victim is an authorized guest. The lease documents show that the victim was put on the lease documents as an authorized guest. He was never evicted or properly kicked out by the defendant, and certainly so to use such force of this manner to try and take someone or kick someone out would be illegal. In regards to her statement specifically, it confirms that at the very least we are eliminating that this is a suicide. We're eliminating that the cause of death is anything more than at the hands of this defendant. In regards to the argument, we get our motive. And that, I'm going to tie that into really a lot of the Williams rule evidence that came before Your Honor in this case. The first, and in this case, is you hear from the mother that she hears the defendant yell, "You're lying, get out." And that is consistent with a lot of the situations that the state put before Your Honor. So, Your Honor, in July 27th, that's the Vegas situation. That is specifically showing and why that event takes place, which is documented inside of the report before Your Honor. The defendant is mad because he doesn't go to bed with her that night. When you talk and you move forward to the October 9th through the 11th situation, where there's the stab wound to the leg, that he's beaten with the phone to the front and back of the head, her only reason was, and she writes it in a text message, "It's because you're pissing me TF off." The January 30th, 2022 through February 1st, which is the slice to the face, and you have the text messages about enjoy the hospital. That's talking about him gaslighting her, not answering her text messages, and she specifically says, "I have to continue to explain to you how to act." We move to the February 21st, and that's the surveillance footage that shows nothing more than the victim trying to use the fob to assist her to go wherever she wants to go, and she resorts to violence, hitting him in the head, pulling his hair. The March 5th situation, which is the top over here, where he confirms to her, "Courtney, but you hit me." The defendant's response is, "Shut the fuck up, bitch. Don't fucking say that shit." And that's because she doesn't want anyone else to hear the actions that she's doing. She doesn't want anyone to know because she doesn't want to get arrested. That's the inference. You move to March 23rd, and those are the recordings that Your Honor allowed in for this hearing's purposes. Specific statements, Your Honor, to read them, you a fucking cunt ass N-word bitch. Shut up and let me fucking slap you, dumbass. And you're an N-word. And why do those happen? The March 23rd, it's because he said hi to another girl that she happened to be on FaceTime with. And so it's another situation of jealousy and not doing what she wants. You can put it down. So what we have is a nature of this relationship, is whenever this defendant isn't happy with how Mr. Ompluselli is acting, she resorts to violence. She resorts to screaming, she resorts to yelling, and the same thing happened on this day. So we sit here today, when we hear her statement, we get the confirmation that the same scenario is happening from the mother. The mother is talking to the detective and says, I hear yelling through the phone. I don't hear any threats, but I hear them yelling. I don't hear any violence, but I hear yelling. And she hears both of them yelling. So you get the same type of scenario where the defendant is saying, you lied. And you get the same sort of motive where she's going to act and keep acting upon it. In this situation, in her statement specifically, she talks about, and she references him as definitely the victim. She used the word exactly, he's definitely the victim. And that's at 3234 in that statement. And then she talks about how there's this whole scenario where she's choked up against the wall, that she can't breathe. And she makes it a very big point in that first time she says it to bring up 2, 3, 4 times that she cannot breathe. Now when she goes through the story again, she doesn't mention it once. And that's an inconsistency. And that's the reality, is because it didn't happen. So when she said she's then brought down to the ground, and these are all during these times, at the point in time where she's now brought down to the ground and she changes this, she says she now changes it from grasping at her neck and holding her to where she can't breathe, it's an open hand. So that's an inconsistency. She then talks about how after this apparent attack, she's able to get away, get her phone, and talk to her mom. What's interesting about that is she then immediately goes and sits next to where the defendant is. How does that make sense? This person who apparently just choked you, attacked you, you're going to now just sit next to him. You're not going to call 911. You're not going to try to leave the apartment. No, you're going to just sit next to him. That's inconsistent, Judge. That doesn't make sense. So she's sitting next to him and she's talking about, and this is where you heard the statement from the mother where he's following her around and they're yelling at each other. When we talk about this whole point in time where she's on the phone, the defendant says this angered the victim. And at that point in time, he's trying to grab the phone from her, so she grabs the knife. What she makes very apparent is her location. She says, so in the photographs that Your Honor has, it shows the knife at the corner edge of this kitchen. She would have to travel close to 8 feet to get to where the refrigerator is, which she says she's in front of the refrigerator, which would mean she would be traveling back to where the victim is. Again, that doesn't make sense unless you're coming to attack somebody. She talks about that, he's running at her, and then she changes her words multiple times in that first statement. First she says he's running, then he's charging, and then he's aggressively walking. And for her sake, thank goodness the detective stopped her, because she would have kept going down and changing how fast he was coming at her.
Objection, Your Honor.
So at that point in time, she goes to explain exactly what her actions are with this knife. And she talks about it, and the detective talks first about how far away. And they try to talk about in regards to the room, and they come to this conclusion that it's not 20 feet, but it's definitely more than 10 feet away. And so she talks about, and he asks her to describe how she threw this knife. And he's trying to give her any out at this point, where he's saying over the head, and she goes, no, I flung it. And she uses the word herself, flung. She flung this knife. There's nothing in that recording that talks about her having any sort of specialized knife training or knowing how to throw knives. And the amount of force that she could have created is nowhere near possible, 8 to 12 pounds, to be able to break through the skin of the victim. And you heard that from the medical examiner, and that's as consistent as can be. The reality is, if given more information, perhaps his opinion changes, but for what's before him, based on her statement, based on who she is, she could not have thrown that knife. So what do we have? We have a stab wound, and that's the medical examiner's opinion. It's a stab wound, and as a result of that stab wound, the victim is dead. And so the state has put forward that not only has she committed this crime, but it's not self-defense, because we've put forward the evidence that contradicts her claims of self-defense, that shows her to be a liar, and to show that she's acting consistent with her nature in this relationship. But most importantly, Judge, she makes this final sort of conclusory statement saying, you know, I don't know, I really don't know if this is justified at all. There's no bigger red flag. She has now just told the detective self-defense and gave this whole spiel of what happened, and then says it doesn't make sense, that it's not justified. So, judges, all of this case has shown that, you know, the victim is dead. That is certain. And it's certain that she did it. And the only evidence before Your Honor in regards to self-defense is her statement, which has been riddled with inconsistencies, with lies, not only by her own mother's statement, by the medical examiner's statement, and by herself. So, Judge, when you talk about the facts that are before you, there's no doubt, let alone proof, evidence, presumption, great, that the defendant committed this crime, and certainly there's a substantial probability that she committed this crime and that she was not acting in self-defense. Thank you.
Defense?
May it please the court, good afternoon. Stay. Judge, a brief apology. We had prepared our summation prior to receiving information that the state was calling witnesses. So the presentation that we have prepared is lengthy, but we will speed through the stuff because we do know Your Honor took the time to go through all of this, and we're just going to highlight some things, but where we can, we will make it more brief. Thank you, Judge. Obviously, the court's very familiar with what the state's burden is in an Arthur hearing. Is the highest burden that we have in any system, civil or criminal. Proof, evidence, presumption, great, higher than beyond a reasonable doubt. It is the highest standard. The court is very aware of these things and has all the case law that we would cite to that. The state judge has failed to present proof, evidence, presumption, great for second-degree murder. Not only that, because this kind of is a mixed hearing, they have also failed to present proof of substantial likelihood that second-degree murder is the appropriate charge in this case. In order to prove second-degree murder, Oglum Sully is dead. We stipulate to that. The death was caused by the criminal act of Courtney Clenney. That's a disagreement that it was a criminal act. There's evidence of self-defense here to rebut any of the state's evidence. And the unlawful killing, again, if it's self-defense, it is unlawful. One of the biggest hurdles the state has here is demonstrating a depraved mind without regard for life and human life. And we'll talk about how that's defined in the case law. Just the definition of what an imminently dangerous act is. The depraved mind portion, which the state fails miserably on, is that this was done with ill will, hatred, spite, or evil intent. The evidence taken in the light most favorable to the state shows that this occurred, this was a reaction by Ms. Clenney defending her life when there was a physical altercation taking place. We know that. The neighbors called, everyone knows it was an argument that took place. This is not the type of offense that second-degree murder is the appropriate charge. Again, justifiable use of deadly force. The appearance of the danger must have been so real that a reasonably constituted prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Clenney must have actually believed that danger was real. How do we know that Ms. Clenney knew that danger was real? It's even in her own statement. And what the state just highlighted, that she's like, I don't know if it's justified. What they leave out, and that's really what the state's case here is, mischaracterizing things and leaving things out, not giving the full picture to this court. At the end of that statement, she says, she's like, all I know is I was scared. The 911 call, you can see her frantic, trying to get help. That eliminates the ill will that the state has to prove in this case. Again, reasonable grounds to believe she was in danger of death. The difference of the physical stature of this individual, he's outweighed her by 50 pounds,
was a lot taller, physically fit. This gentleman could wreak havoc on her had he chose to. Let's talk, the misrepresentations that I'm talking about came out during a lot of the testimony of the detective, so I'll kind of speed through this. But to highlight, the video, the elevator video, again, the way this elevator video was presented to the media at the state attorney's press conference and by the state, she's not holding the door for him. She was panicking to get that door shut. It's clear. And what does Omlumseli do? He blocks her out like a basketball player. At some point, puts her in a headlock, and he is able to access the file, again, to access the apartment. During the show, you can see he's able to access the panel as he pushes her around. And then at the next slide, I believe, is when he's taunting her. You can visibly see him taunting her. That's the type of individual this was. And he's laughing.
And Judge, objection, that's not evidence.
The video, I know you want to review the video. Again, the insinuation that Miss Deborah Clenney, her mother, is trying to have her put forth some type of self-defense, they put that in the warrant, not seeing the whole text. But we have the whole text, and I know Your Honor's seen it. Clearly, this is a concerned mother trying to get in touch with her daughter after she doesn't even know the severity of the situation. Doesn't know. The detective never told them. The other misrepresentation. The defendant's physical body was documented on the date of the incident. There were no injuries to that person to corroborate this account. Again, there's injuries, there's visible. The state made arguments about when they occurred and they could have been earlier or they were there previously. What we do know is she had fresh bruising as well. So whether they were there before, there's additional bruising that was not provided to...
Objection as to the word fresh. There's no evidence of that.
There's also evidence of the mental abuse that Courtney suffered at the hand of Omlumseli. These were in the decedent's own words about gaslighting, mentally abusing, her causing her hurt and pain. Again, these were provided to the court. He's apologizing for his gaslighting. He holds himself responsible, not in his character, blames it on using a lot of blow. Again, evidence of his physical abuse towards her, which goes to the self-defense in this case. Again, we're not going to play the audios. We know Your Honor listened to it, but what's very key to the lead detective's investigation is the statements by the neighbors. These are independent witnesses who saw blood in the elevator, was told, again, this is like, I think, double hearsay, but was told by a resident that Omlumseli punched Courtney in the face. That same witness, J.S., observed Courtney trying to climb out of the sunroof of the car as Omlumseli was trying to grab her out of the car. Again, evidence of the abusive nature of Omlumseli, which goes to self-defense. Again, J.S. looks like she was being abused. He called it like he saw it. You listen to the interview. The neighbor said whenever she was by herself, happy, smiling, would say hi. When Omlumseli present, quiet, looked down, didn't have any conversations. Again, evidence of the abuse that she suffered, which Mr. Clenney knew very early on when this relationship got toxic. Again, another neighbor, EP, same thing. He said there was a weird vibe in the elevator. Clearly something was amiss in this relationship. Again, independent evidence of a toxic relationship. This neighbor also talks about the event in the dog park where Omlumseli aggressively grabbed Courtney by the tricep. He was so concerned that he said he stayed watching in case something, quote unquote, went down. That's the type of relationship she was stuck in. The physical abuse, again, we have the audio of her screaming. Again, this recording was taken by one of the security staff at the One Paraiso. She didn't know anybody's out there. She's recording it. We have Courtney's own words about being kicked in the leg by Omlumseli. Again, these are the bruisings that were taken by Miss Clenney after Courtney was taken out of the after being Baker acted. It was a very traumatic experience on April 3rd. The courts reviewed these. A lot of these bruises speak for themselves. Courtney's plea for help, again.
It's all under my name. I think.
Okay, just to have the judge, again, this is so clear, she's trying to get a restraining order. She testifies as to, had he been violent in the past? She says yes, and the officers kind of just they brush right past that instead of saying, hey, why don't you tell us about that abuse? She does say that's not her thing, but she knows she wants him gone. 2 days, less than 48 hours before the incident.
It's all under my name. I pay the whole rent. He has never paid a second time of rent. He has never paid a friend. I broke up with him. He said my mom came out. So I told him to break up with him and I just said, he sat in my elevator room inside of the coach. He's so confounded. And I was like, let's just stop.
We get down here to the lobby area where our boyfriend comes charging.
Again, what's important, Judge, in that video, I know you've seen it, independent witnesses talking about Umlumseli charging at Courtney to the point that they had to intervene, which is consistent, again, with what happened on April 3rd, where she says to the detective, he was charging at me, running at me, coming at me. I could see the whites of his eyes. Not an isolated incident of abuse by Umlumseli on Courtney. No problem. Judge, you recall the end of that video, crystal clear. I want a restraining order against Umlumseli. Judge, important, again, mischaracterization, misleading by the state in this case. This is the video of the officer in Las Vegas where Courtney gets arrested for domestic abuse by throwing a glass towards Mr. Umlumseli that she admitted to the officer. What the state doesn't tell you is at the beginning of the body-worn camera is that this security officer tells him, hey, my people went upstairs and there's clumps of hair on the floor. There was a struggle. And again, Courtney protected Umlumseli, didn't say anything until she realized, wait, I'm getting arrested. Officer, I didn't tell you everything that happened. Well, you could, I'll supplement my report, but you're going to jail. That's what happened. Courtney was abused that day by Umlumseli. The video, I'm sure Your Honor saw it, the condition of Mr. Umlumseli on that video in the morning. And you could see how Courtney's interaction was with the detective. The state failed to provide Your Honor this information.
The female calls while she's calling security. She's basically saying, like, get your hands off me. We get up there. They both at one point commit to physical altercation inside of the room. The room upstairs is disaster. Okay. I think there's an alleged hair pulling of her. Alleged hair pulling? Hair? Oh, hair pulling, right. The guy is saying that didn't happen. So, I just walked by and he's like thrown up into a trash can, so I have no idea what their deal is. Sounds like they're both thrown.
Again, that officer says both people admitted to getting physical. Courtney ends up going to jail for that one. This is the end of the video where she talks about, I'm not telling you everything.
Consider battery of domestic violence as a mandatory arrest.
Okay, there's a lot that I didn't say because I didn't want him to get in trouble.
Again, protecting her abuser so that he doesn't get in trouble. The text messages, the state has tried to make a case about what these text messages show. Again, these are text messages. They're lacking in context, they're lacking in tone, they're lacking in expression. If this is the state's case, it definitely doesn't meet the standard of proof evidence presumption grade, nor substantial likelihood. Again, what's important about these text messages are, after there's some discussion about some incidents, what always happens is Courtney says to Owamseli, go ahead and tell them what happened, because then I will say what really happened. I'm not afraid. She was not afraid to say what would happen if he called the police. And those are what these text messages show. Clearly, Judge, we're not denying this was a toxic relationship. Mr. Clenney knew it. Ms. Clenney knew it. Everybody knew it except for Courtney and Mr. Owamseli. He says, I'm not saying anything because tell them your side and I'll tell them what happened. And he never says anything because he's afraid of the truth, because the truth would hurt. The state tries to say that Courtney is acting, I think that what the state's trying to prove by some of the text messages was like, oh, that she's acting in ill will by her use of certain things. Again, these are text messages without context. She mentions, too, without getting into the details, but in her interview, I know Your Honor's looked at it, she talks about Christian, I believe, was holding a knife to himself in the bathroom, he committing self-harm.
I don't remember exactly what the situation was, but he was, he had taken a knife, he grabbed it from my face, and then I got scared, and he was kind of waving at me, but it wasn't for me, and then he took it to the extra room and slammed the door, and he had a history of self-harm, so I kind of was like, okay, well, I'm going to change it. Regardless of what's going on, and I tried to open the door, and he went out the door, so I got really scared that he was doing something and I couldn't control, so I got caught. And he wasn't very happy with me about that, but I was really scared. And he threatened me many times, but I don't know where he was right then. Bipolar.
We know, again, the nature of the relationship. It's described by Courtney, and in the context of this, we know that Courtney, when she describes this attack, clearly had no other choice but to defend herself. She talks about seeing the whites of his eyes and her level of fear.
We stayed like against the couch. Like we were obviously it was so big deal. So this happened like over by the door, and he somehow just take over and we were standing by the couch, just before the kitchen, I was in the kitchen. And then he started all right inside, and he was like coming at me. And so I grabbed one of these knives, like I'm coming for Christmas, I grabbed one of them. And I was like, I swear to God. I swear to God. It was just like, I was like, don't come any closer to me. Because earlier, I had this really time I couldn't fucking breathe. I'm sorry. I couldn't breathe. And it's very scary. And I just think, just like that, thing, like, you know, he's okay. If he's choking and he's angry enough, he might this is different, I think. But if he's choking or hitting you and I can't breathe, he might go slow. So I grab my knife, I said, don't come any closer to me. I have absolutely no intention of using it. I was calling my mom, and he's coming at me like he's going to grab me with a phone or the knife or something, and so I was just like, don't come any closer.
Now, what's important here, the state, talks about, I flung it. The detective in this case couldn't remember a lot of things. Your Honor can evaluate his testimony, but what's important, especially in this type of case, would be, hey, you know what? Let's talk about how you flung that knife. Did you throw it? Did you wind up? He never goes to have her describe that. Really fails to have her go through, because that would have been something that probably should have been done. Show me again. How did you throw the knife? He goes through this statement with her 3 times and never goes and does follow-up. But again, Your Honor has gone through the full statement. It is not inconsistent. The detective even said, I asked a couple of times because sometimes people remember more detail when you go through it again. And that's what her statement is. It's not inconsistent at all. Again, at the end when she says, he asked her if this is justified, which obviously is a legal conclusion, but at the end, which the state, again, leaves out, is when she says...
I do not think that this was... I don't know. I really don't know if it's justified. Because I know
Judge, the evidence that the state had, the state's own evidence provided to the defense discovery casts doubt in substantial respects as to, number one, proof evidence presumption great, substantial likelihood, proof beyond a reasonable doubt clearly. The state's case, and it's the State versus Perry, I provided that to the court, they have failed here, Judge, to put forth sufficient evidence for second-degree murder. Again, the Seymour versus State case, 132 Southern 3rd, 300, the language in there is very important for this case. The facts would support something other than a guilty verdict on second-degree murder charge, then the proof is not evident presumption great. Judge, that's exactly what we have here. Again, even if this is not a case of self-defense, although it is, the case law is clear. Extreme recklessness or an impulsive overreaction to an attack or injury is in itself insufficient to support a second-degree murder conviction. That's what we have here. There's no, clearly, under the case law, there's no proof evident presumption great. An impulsive overreaction to an attack. Let's say this wasn't self-defense. Let's say she shouldn't have thrown the knife. An overreaction to Munselli's impending attack, finishing off what he started earlier by choking her. An impulsive overreaction to an attack or injury is insufficient to prove what's an essential element of second-degree murder. It's insufficient to prove ill will, hatred, or spite. And it is well supported by case law by all the district courts in this state. Again, even if her conduct is reckless, let's assume again she wasn't defending her life that night, which she was. Extreme reckless behavior in itself is not enough to infer malice. Again, no ill will, hatred, spite, or evil intent. Well supported by case law, the state has failed to present sufficient evidence for second-degree murder in this case. Again, even if we're talking about a jury, which that would only be beyond a reasonable doubt standard, and they were to reject this self-defense, and again, impulsive overreaction to such an attack does not warrant a conviction for manslaughter. Warrants a conviction for manslaughter, not second-degree murder. And I believe that was an appellate decision that overturned a conviction and directed the trial court to enter a guilty verdict to manslaughter, reducing the charge. There was a lot to do yesterday, and I know the court asked for some clarification about the timing of these phone calls. The defense went back through this last night and dissected the cell phone records in great detail, in combination with the reports that we supplemented, Your Honor, today. Now, this is very, very important, Judge. This is the cutout section, okay, from the state's own phone records, the cell phone records from Courtney's phone. And what we have here are the two phone calls at the top to Mom, which, by the way, in Mom's statement to the detective, I'll get to that in a minute. These are the first two phone calls. This is the time of those phone calls. Okay? The first call to Courtney to her mother, the top one, is at 4:43 p.m. That call lasts 393 seconds, converted to minutes, 6 minutes, 30 seconds. If you add that to the call start time, that brings you to 4:49. That's Miami time. I converted this number to Miami. So, what do we know? The second phone call starts at 4:49. So that's a hang up and a redial immediately. So there are two phone calls, which, by the way, Ms. Clenney told that to the lead detective in her interview. So we have those 2 phone calls. Now we know that, so that takes us, if you add that, 430 seconds, the second phone call, that brings us to at least 4:56, possibly 4:57, because it only has the start time in minutes. So we don't know the seconds. So for example, this start time of 20:43, which is at 4:43, could have been 20:43 and 59 seconds. So there is some type of gap here that we don't know. But what we do know, when you add the amount of seconds, you get to consecutive phone calls being placed by Courtney to her mother. Now, what we know is, based on the report by the security staff at 1 Paraiso, at approximately 4:50 p.m., this security, the front desk person, who's Marvin Durant, the front desk personnel, right, calls security, who's Miss Ormeal, okay, who writes this report. Mr. Durant called the police at 4:44, while myself, Miss Ormeal, and Danny, another person that works here, went up to the unit. They knocked several times. No one answers the door, but we could hear them yelling and screaming at each other. So, we know at 4:50, and however long it took them to get upstairs, Mr. Olamselli is still arguing with Courtney. Then we have Miss Orville state, but we could hear them yelling and screaming at each other. I then dispatched the front desk to call the unit. She gets on the radio, calls the front desk and says, hey, call the unit. Call the occupants of the apartment. So we now know at that phone call, right, we know Courtney's on the phone with her mother. We know 786-472-8232, no answer. Calls Courtney's phone at 20:53, which is 4:53 p.m. These calls were not answered. So we know that at 4:53, okay, so what we know, Judge, at 4:53 is when that call to the front desk is made by security who's standing outside the door. So we do know at 4:53 p.m. they're still arguing. So at 4:58 p.m. they both decided to go back to the unit, in which Courtney Clenney finally opened the door. I'll just let you guys talk.
I can't hear. Go ahead.
You let me know when you guys are done. Thank you, Judge. At 4:58, they go back up to the unit. And what do we know? Based on the phone call to 911, at 4:57, Courtney called 911. So, we believe the evidence shows that Courtney called 911 immediately after the incident. But, with certainty, based on these objective records by independent witnesses and phone records, what we do know is that the incident had to have occurred between 4:53 p.m. and 4:57 p.m. when she called 911. The state tries to insinuate that this occurred during the first call to Courtney's mother and that she let him bleed out. And that's contrary to the state's own evidence, Judge. There's a 3-minute window here, or 4-minute window here at best. At best, in the light most favorable to the state. And it's irresponsible to say otherwise.
So we went in the unit 2201. We knocked on the door. Nobody answered the door. We didn't hear nothing. So they were talking. Once we were knocking at the door, they stopped. We don't hear nothing. They were talking. They were like cursing, like verbal talking. So I said, okay.
So that is the verbal statement that corroborates her written report that she made to the lead detective in this case, talking about when things occurred and that she could hear them arguing. Then when the knock came, they stopped. And that's when she called the front desk, dispatched the front desk to make those calls, which show up on the phone records.
Yeah, once we're knocking at the doors, everyone's talking. No one wants to, like everything was fine.
Okay.
And then I said, Dane, so he's like, you have to open the door. Okay. We went and checked on the next door at 22. This is 2201 that happened. So we went on the 2202
Okay.
to ask them question. They did not answer the call, the door. So I'm like, can you, I radio called the front desk to call 2202 to ask them question. 2202 did not respond. So I'm like, okay then, this time let's go back to the unit. At the time, paramedic is on the way. So let's just go, let's just go back to the unit to make sure they're all right. So when we went back, that's when she walked to me, the lady, a white lady, she walked to me fully with blood. She was like, help, I need help. And then I'm like, what happened, everything's up.
So, when they go up to the apartment again at 4:58, Courtney comes out, having already called 911 at 4:57, comes out seeking the assistance of security, screaming, covered in blood, begging for help, like she did on the 911 phone call. Again, eliminates ill will, hatred, malice, which the state has to prove for second-degree murder. Under any standard, they failed.
She told me that she was on the phone with you when part of this incident was going down.
Yes, she was.
So around what time was it that you guys were on the phone?
I looked on my records a little bit ago, so let me look back and see exactly what time that was. Let's see. Okay, it looks like she called me at first at 3:43, and we talked till about two different phone calls, talked till about 3:56. That's what it looks like, but I'm not 100% sure.
Again, Judge, the state tries to tell you that Miss Clenney is lying to protect her daughter about the one phone call. Didn't say anything about two. She tells the detective two phone calls, and she gives the exact start time and the exact end time that corresponds exactly to the phone records we have. There's nothing untruthful or deceptive by Deborah Clenney in this case. She again describes what she heard. Again, talking about the detective in this case, he never followed up with her about telling her what else did you hear?
I heard her say, you lied, just get out, just go away. I'd actually been out there for 6 days trying to get rid of it.
You lied what?
She was saying you're lying, and he was saying I'm not lying, but I really don't know what the whole thing was about. I didn't know he was there. I thought he was gone.
Again, she describes what she heard during the calls, and the detective, again, after I arrived at the Homicide Bureau, doesn't follow up even after the Clenneys offered to make additional statements.
So, in the argument that you overheard today on the phone, how was he? Did he sound aggressive, or was it just like a regular, like normal volume voice, or?
He was screaming at her.
Yeah.
Because I told her to tell him to stop screaming.
Yeah.
And so, no, he was screaming at her, and she was telling him to leave, but he was screaming. I couldn't hear what he was saying. I could hear her telling him to go real good. And then the next thing I know, she's calling, crying, yelling for him to get out. I go, how are you doing? She didn't tell me that part.
Okay.
She yelled her to get out. She yelled me live. And he was yelling at her back. And actually, he was screaming because I thought that, security, I didn't think police, security was giving me a call from the yelling. And the dogs were barking as they did, but Christian started.
So we do know that Ms. Clenney did describe what was occurring to the detective. And again, he got interrupted by my arrival at the Homicide Bureau. But what we also know is that during the course of the conversation with Ms. Clenney, you can hear Mr. Clenney in the background. The state made a whole to-do about, he was on the phone and he wouldn't have wanted him on the phone. No, at no time does the detective say, you know what, Ms. Clenney, I need to talk to you privately, so could you have your husband get off the line? You can hear Courtney's dad in the background while Detective Briseño's interviewing her. And then when he goes down to get me at the Homicide Bureau, you can hear Mr. Clenney, Miss Clenney, talking the entire time. And Detective Jerez is in the room listening to them, recording their conversation. So she knows that Mr. Clenney's present. Mr. Clenney tells the detective, oh, the attorney's there. He's like, I'm happy to answer your questions, but the attorney's there if he says so. And then Kim Clenney says, and we're happy to visit with you if you want. So the state's saying that this is some kind of them not being forthright and disclosing everything that they know at the time is just disingenuous.
Well,
It's freaking out.
okay.
And we're happy to visit with you. It's just he's there. He just want to be as long as he was.
Again, what I said earlier, you can hear them talking. You can play that clip.
So pretty much just to catch up, Mr. What's your name? Prieto. Pretty much she called you around approximately 3:43 to like 3:56 p.m. From your calls. And pretty much you overheard him and her talking. You lied, and he was arguing back. I'm not lying.
Actually, the main thing she was saying was, get out, please, go away. That was actually, she did say he lied, but the main thing she's really trying to say is, get out of here, go away.
Yeah.
And you're really not basic. And that's exactly, this is Kim Clenney, her father. That's exactly the same.
Now, what's important here is, obviously, Mr. Clenney gets on the call and starts talking. And when Your Honor listens to the statement in its entirety, Detective Briseño never goes back to asking more follow-ups. At that point, he terminates the interview. And so he knew Kim Clenney was there. They knew that. And for the state to mischaracterize this evidence, again, disingenuous. Now, Judge, I said, at best, if we look at the facts of this case in the light most favorable to the state, at best, this is a manslaughter charge. This is a self-defense case. Courtney was in a struggle for her life. But if that, if you take that out of the equation, at best this is manslaughter, which is a bondable offense, which has a $25,000 scheduled bond actually assigned to it. To prove manslaughter, the state would have to prove Mr. Omboselli's dead. Courtney intentionally committed an act or act that caused the death of Omboselli, which would be the throwing of the knife. Clenney intentionally procured the act that caused the death, or the death was caused by culpable negligence of Clenney. At best, in the light most favorable to the state, again, the standard for an Arthur, but even under pretrial detention, at best, this is a manslaughter case, which is a bondable offense, which is why this court should grant a bond. The Menini case is very, I think, I believe this was a habeas petition filed by Menini, that it may well be that the jury could conclude that Menini acted without justification and is in fact guilty as charged. Again, that's what the court could find here, or a jury could find here, if it wasn't a case of self-defense. But on the other hand, the facts as presented to the circuit court are also susceptible of interpretations ranging from a lesser degree of murder down to excusable homicide, which is what we have here. Again, habeas petition taken up to the 2nd District, which then directed the trial court to issue a bond. Judge, I will, for the rest of the arguments, since Ms. Puglisi addressed the second phase, kind of with Mr. Clenney, I'd let her conclude our summary of the presentation.
Judge, I didn't know if you wanted, wait, did the state even make their arguments regarding?
They haven't, but generally phase 2 is your burden, so I will switch it to you. I do want to go ahead and hear both phase arguments today. Did you have anything you wanted to?
Yes, sir.
Yeah, no.
Also, Judge, I don't know when you want to hear from the next Kim's attorney, but Mr. Hansfield is also here, so.
Would you like to make a statement?
Judge, I'll wait till after they finish and then I'll make a statement.
defense brings up this idea of no ill will, but the reality is ill will in all that case law really talks and points to the desire to injure. And that's exactly what we have here. We have this situation where defense wants to bring up this self-defense and this idea, and they bring up the mother's statement, the timeline of the 911, but there are facts that they're misleading this court. For one, when they talk about the 911, when they talk about the 911 calls and the call log in general, when they say NA means not answered, that's not actually true. Because Your Honor has a key, and that's specifically going to talk to the connection type. It has nothing to do with whether someone answered. Actually, the amount of time that shows up. So if a call goes for longer than 5 seconds, the call was answered. There's multiple calls on there that are less than that, that go up to 18 seconds. 18 seconds is going to mean that she answered that call. And so that's exactly what that is. So when defense tells you NA says not answered, that's incorrect. When we talk about the 911 call, when we talk about the timing, if Your Honor wants to take the mother's statement as true about her being on the phone until 4:56, and then Ms. Clenney calling at 4:57, what that means is she's on the phone while the stabbing occurs. And what that means is she did not give that information to the detective. So she's misleading this she is misleading the detective in whether or not the information she knows is true or not. In regards to that statement specifically, there's a number of different things that are important, Judge. And that would be that what she didn't do and what Ms. Clenney didn't do. So she tells this court, or she tells in the statement that the defendant's telling the victim to get out, that he lied, to leave and go away. But what that would also indicate is that the defendant never told her mother that she was grabbed by the neck, that she was slammed on the ground. Because as a mother, the first thing you're going to do when a detective tells you what happened, what did you hear, is my daughter was being beaten up, abused. Didn't happen. Why? Because the defendant never told her mother that. When we talk about the description and the amount of time that goes through from those calls, you have a situation where there's more than enough time. There's 14 minutes that go by from the point in time that the defendant is on the phone with her mother, that this situation occurred, that she doesn't call 911. Not only that, but based on her own statement, she would have been on the call for this occurrence. She doesn't call 911, which is another indication that the mother is also trying to support her daughter and defend her daughter in this situation. Defense brings up, and they showed a number of photos of bruising. And their assertion is that these bruises occurred during this incident. What they didn't show you, Your Honor, were any bruises of the victim's, of the defendant's neck. Because if the defendant was held by her neck to the point that she could not breathe, that she was then put on the ground and held on the ground by her neck, there would also be bruises of that. And yet, none of those are before Your Honor because they don't exist. Which also now contradict again the defendant's statement. And Your Honor, the testimony is clear. The medical examiner made it very apparent that unless there's some sort of information before him that this defendant is a knife-throwing expert, she would not have been able to throw this knife to where it went 3 inches into his chest, and that led to his artery being severed. So we stand here with a number of items of evidence that contradict this claim of self-defense. That and the fact of her history of showing that she is the aggressive one in this relationship. Self-proclaimed. In her own statement, she says she's the aggressive one in her relationship. It just doesn't make any sense. There's no way that she would have been able to throw this knife and have it land into his chest to the point of the depth that it did, and with the amount of force to break through the skin. And there's no evidence that contradicts what the medical examiner has come here and said before, Your Honor. So, Judge, at the end of the day, the defendant is caught up with her back up against the wall. She has a situation where she has acted out as she's shown consistent with the nature of the relationship. She stabbed the victim. He's dying. He's bleeding. She doesn't know what to do. She's on the phone with her mother trying to figure out what to do. And that's consistently shown that she's trying to plan and figure out what to do. Finally, she calls 911. And at that point in time, when she's brought down to the police department, the mother's text messages indicate to her and allege self-defense. And innocent people are found guilty all the time. You don't text that unless you know what happened in that room, unless you heard what happened, unless your daughter told you he's been stabbed, that I stabbed him. That's why you bring up self-defense. She doesn't mention any of that, though, when the detective is there. And so that's the reality, is she's hoping that her daughter still has her phone so that she's going to hear that, see that, and not give the statement that you put before Your Honor. That doesn't make sense. So, Your Honor, we've brought forward the evidence that we have. We've shown that she is inconsistent with her story. She's been contradicted by numerous witnesses, including her own mother. That the bruises that defense has brought to you, they don't make sense. So, at this point in time, Judge, there's no other reason to know what happened in that room other than that this is the defendant acting out and consistent with what she's done in the past. That she didn't like something that Mr. Clenney did, and from the victim's mother's own words, lying. She wanted him out, and when he was trying to defend himself, to have some conversation with her, she stabbed him. So we're here, Judge, because the defendant has committed a second-degree murder. She stabbed him. The victim is dead. She's shown ill will, hatred, and spite, and as a result of her actions, it's not a justified killing. So, at this point, Judge, we believe we have met our burden, not only for Arthur, but also under pretrial detention. Thank you.
Defense, and again, Mr. Hanfield, since you're not one of the parties to the case, I will definitely allow you to give a statement. It doesn't have any evidentiary value, but I know that you've been respectful.
Thank you, Judge. I mean, obviously in State v. Arthur, Your Honor, once you make a decision, even if you find proof evident presumption great, the court still can grant a bond. There are various factors that Your Honor would need to look to. And specifically with respect to the Florida statute, 907.041 pretrial detention, it talks about pretrial detention and the various factors or circumstances that the court should look to. Specifically here in this case, the state is moving forward on subsection C1 that the defendant has previously violated conditions of release and that no further condition of release are reasonably likely to assure the defendant's presence at subsequent proceedings. And subsection 5, which says that the defendant poses the threat of harm to the community, the court may so conclude if it finds that the defendant is presently charged with a dangerous crime, which we do concede that second-degree murder, even manslaughter, is considered a dangerous crime pursuant to the statute, that there is a substantial probability that the defendant committed such crime, which we disagree with, that the factual circumstances of the crime indicated disregard for the safety of the community, and that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. And that's where really this dangerousness comes into play, which is that there's no conditions of release to protect the community. And based on 907.046, the purpose of and criteria for bail determination, there are the normal circumstances, the nature and circumstances of the offense charged, the weight of the evidence against the defendant, which obviously you heard a whole hearing and have evidence on. The defendant's family ties, length of residence in the community, employment history, financial resources, and mental condition, past and present conduct, Then it goes on to other factors like the source of funds used to post the bail, whether the defendant is already on release pending resolution of another criminal proceeding, the nature and probability of intimidation and danger to the victims, whether there's a probable cause to believe the defendant committed a new crime while on pretrial release. With respect, there's no evidence that there would be any intimidation or danger to AblamosTV's family or anything like that. And with respect to committing a new crime while on pretrial release, I don't believe there's any evidence to support that. But going specifically, Judge, to why Courtney is not a flight risk. First of all, I understand she does not have ties to this community, the South Florida community. But she does have ties to the United States, born and raised. She was raised in Texas. She obviously, as you know, is very close to her parents, who are both here today, Deborah and Kim. She has a sister. She has many aunts, uncles, cousins. She has grandparents, and they all live in the Texas community. So she has strong ties to there. As far as aware of the pending investigation, this is really important because unlike many murder cases that we see, usually they arrest the defendant right on the date of the incident, right? In here, actually what we have is she met with the police, she gave a full statement to them, and then they released her. And she remained out on release up until her arrest while she was in a rehabilitation program in Hawaii towards the end of August. And it's especially important because this happened in April, and so she remained out of custody for over 4.5 months approximately. And she was aware of that investigation. Obviously, she had an attorney. She was in constant contact with him. If she wanted to flee, Judge, she could have at any time. She knew she had an investigation for a murder charge. She already knew she had actually stabbed Mr. AblamosTV, so there was no question that if she felt fear, she could have fled at that time. And that's where the financial status comes in. It's important. The reason we put Mr. Clenney on today was for the court to understand she did not have over $2 million. She does not have a substantial amount of money. She did. All that money has been spent, one, creating more ties to this country, right? If she was going to flee, why would she pay $335,000 to the IRS? Why would she purchase a home and pay another almost $380,000? She could have taken that cash. At this point, she has $11,000 or so in her name as far as cash goes, and she could have already left. She could have already spent that. Participation in a treatment program. Your Honor can consider mental health and should in this case. You know, there's no question that she needs treatment, not just for the PTSD, but as you heard, there's allegations, and I don't think it's really allegations. She had an alcohol and substance abuse problem, and that is seen in audio recordings and Las Vegas, where they said they were both drunk. She needs treatment, and she knows it, and she knew it while she was out pending this investigation. In fact, she went initially to a outpatient program. She realized that wasn't good enough. It wasn't helping her. She was still drinking very heavily. And so she signed up to go to an inpatient program, which she got COVID and she couldn't go to. And then she looked into the program in Hawaii and was there for about 8 days before the marshals came to arrest her. But she knows she needs treatment. She still wants that treatment. We have looked into it, Your Honor. We were able to provide you with a letter from Emerge. It's a outpatient treatment program in Texas. She did attend that outpatient treatment program before, but they determined it was not sufficient. She needed inpatient, but they are willing to take her again. And so she would, as part of a condition of the bond, we would be saying that the judge should put, Your Honor, should put a condition that she does attend outpatient treatment program as required or as recommended by the program. We know that this was the letter, and you have this, Your Honor. It's the letter from The Exclusive, which was the program that she attended in Hawaii. And what we know is that during that time while she was there, she was diagnosed with PTSD, alcohol use disorder severe, and cocaine use disorder severe. But despite all that, she was making great progress before she was removed by the U.S. Marshals. There's no question of her following rules or regulations. She's done it before, and she will continue to do so again. Obviously, I think the DUI warrant, we have to discuss it. It's probably the most important thing, because Your Honor should consider whether somebody is not somebody who can appear in court. And whether they have failed to appear in court before is something that you need to look to. And in this case, she does have a warrant out of Texas for a DUI. Now, that is not because she failed to appear, though, honestly, Judge. What happened, as you saw from the affidavit we provided from her attorney in Texas, Mr. Anthus, is that she actually did appear in court on the day she was going to take a plea. And unfortunately, she was under the influence at that time. And the attorney advised her that you cannot take a knowingly and voluntarily plea when you're under the influence. The judge will take you into custody. What you really need is an inpatient program. It was her decision to leave, which she did. A warrant was issued. But immediately following that, Judge, she did go to find a treatment program. Throughout the entire representation of Ms. Clenney, and Mr. Anthus also represented her in 2015 for her other DUI, which are the only two cases that she has criminal history for, where she has convictions. And back then also, she maintained constant contact. One of the things the state talks about is her fleeing. They use that word in their pleadings, that she fled the jurisdiction. First of all, she did not flee Miami. She has really no ties here, right? She moved here with Oblinselli, but she has no family here. So after the incident on April 3rd, she was not going to remain here by herself. She went back to Austin, Texas to be near her family. That's not fleeing. She was in contact with her attorney, who was also in contact with the state attorney's office, and they were aware that she was in Texas. She likewise did not flee the jurisdiction in Texas to go to any of these, to California or Las Vegas. There are no court orders that precluded her from traveling. The state has not provided any court orders. They just say that she left without order, but there's no order that says that she was required to do so. And in both of these cases, he said it was not a violation of Ms. Clenney's bond for her to leave the jurisdiction. Now, one thing I just want to advise the court is she has been offered a plea by the state attorney's office in Texas. It is a plea to time served on that misdemeanor DUI case. She signed the plea and abstention documents the other day when we were in court here on Tuesday. She has court there on November 28th. At that time, the warrant will be vacated and the plea will be entered, and that case will be closed. Courtney is not a danger to the community. Type of crime alone is not a reason to deny the bond. And again, the state puts in various cases, but as Your Honor knows, they were dismissed. The two convictions she has are for DUIs, and we agree she needs treatment, and sending her to a program requiring that will ensure that she does not drink, and that can also be a condition that she does not drink throughout the bond. We know this was a tumultuous relationship, but this was a relationship between two individuals. Your Honor has to look to see if she'd be a danger or harm to the safety of the community. There's no evidence that she would be a danger. If released, she'd be a danger to the rest of the community. This is really a one, it was based on a one relationship, and that's it. And the length of delay to the charge is very important, Judge, because it's tough for the state to say that she's such a danger and harm to the community when they let her remain on a bond pending investigation for 4.5 months. And I know it's easy to say, well, their investigation wasn't complete. Maybe they can say that. But the medical examiner had his opinion already. And he said it wasn't self-defense. And that was concluded back in May. And if somebody is truly dangerous, you don't leave them out on the streets. You put that case to the top of the pile and you work on it and you get it done. You don't leave that person out. They could not have felt that she was that much of a danger if she's been out for 4.5 months. There are conditions of release that could reasonably sufficient to protect the community in this case. A monetary bond, her parents would be the one that would be paying this bond judge. We have a bondsman, Mr. Valunza from 305 Bail Bonds is here, and he has spoken to the parents. He has an understanding of collateral and everything that would be involved, and he is willing to accept the bond in this case. Home confinement with GPS monitoring, we do think that that would be the best way for the court to ensure with permission to attend program. She should only be at home, going to treatment, and going back home. Judge, because we're asking that she be released and be allowed to return to do house arrest with her parents at their home, we understand. I spoke to house arrest, home confinement here in Miami, and they can only be monitoring cases in the Southern District. And so I found a private program. It's called EPS Monitoring Company, and what they do is they use the same kind of GPS trackers that other programs do. It is a program that the defense would have to pay the costs of that supervision, but it is similar to what we have. It's a GPS, it's a bracelet, it goes on your ankle, and they monitor everywhere they go. What they advised is they get told what the court wants. So if the court says she's only allowed to be gone from her home from such and such time to such and such time for her program, that's what they will do. They will also, law enforcement and judges can have individualized scheduled updates on the offender status. They can give you weekly updates, Judge, if you'd like, on what she's doing. They can give it to the state. What they said was that if she violates, if the court wants, the court would be the first one to know, but they keep track of all of that. So, Judge, just in conclusion, I want to say that there's no question this was a very toxic, tumultuous relationship. But the activity or the involvement of law enforcement in this case, I would really describe it in one word as dismissive. Because she gave a statement on April 3rd, and what we know is that she had visible markings on her body. And the detective at no time asked her, can you please tell me about those markings? She says she was choked on 3 occasions, one being that night, and the detective didn't ask her the details about those other 2 occasions. We know from Las Vegas that she talked about protecting her offender, and we know from all cases of domestic violence, there's so many out there that the women protect their abusers. It is not uncommon. Everybody knows it. And that is very clear from the evidence here of where she said she was trying to protect him. And those text messages saying, I will tell them what really happened. And then we go to 2 days before this incident where the police are called. And once again, they ask her, has he ever been physical with you? And she says, well, yes, but that's not my concern. Once again, she's protecting her abuser. But what the police should have done is they should have said, hey, we're trying to help you. Have that compassion.
And Judge, I'm going to object as to phase 2 argument, the relevance. of what the police should have done.
They didn't do that, and you know what, Judge? We could see her fear in that video when she asks for help. And she was so brave that she told the police that day that she was scared of him. But like so many people, she took him back the very next day, and this is what we see, what she tells the police in her statement. So it was definitely 2 nights ago. He explained the whole thing, and I was like, okay, you know what, let's agree. We will never touch each other again out of anger, and you will never gaslight me again. And those were the 2 main things, and this was very late at night, so the last couple of days have been, he was just great. He was happy to be back in the apartment. I was happy to have him back at the apartment because I missed him, and because been waking up telling me good morning, I love you, touching me like, it's just, I felt very, very loved when I woke up this morning. Before, I am so heartbroken. It's just like, why? Because he did not keep his promise, and she had to defend herself. And so, Judge, we are asking, not only from phase 1 that the state has not met its burden, but now in phase 2, we would say that there absolutely is no evidence that she would be a harm to the community, and that there are reasonable conditions of bond that could be set. Upon release, Mr. Prieto and I would pick her up, personally take custody of her, fly her to Texas to get the bracelet monitor put on her ankle, and take her to her parents' home, so that we ensure that she does get safely to the house and she's there. So we ask the court to grant a bond in this case.
So, Judge, the question is whether she's a flight risk and a danger to the community. In regards to the flight risk component to it, defense concedes she has no communal ties here to Miami-Dade County. They've conceded that this court cannot monitor her with any systems that we use here in Miami-Dade County. This court would have no control over any sort of system that would be in place over in Texas. It would have no control if the defendant decided to cut off her monitor and flee. It would have no control if the defendant's family decided to assist her in trying to leave the jurisdiction. The defendant has the not only means, but the ability to make money without your conventional job. Her job, all she needs is an internet connection. And so the situation would be that if she decided to, and there's no evidence before this court about the financial means of her parents, and certainly there's a number of dollars that the records aren't corroborating. There's a significant amount of money that's still outstanding based on what has been spent. But the defendant has the means to not only charter a private jet, but also to continue her work in another country. So the OnlyFans company is not a United States-based company. And so not only does this court not have jurisdiction over it, but the federal government would not have jurisdiction over it. In regards to violating her release conditions, she's violated not only in Texas, but also the Vegas arrests. So she has not only a 2015 DUI Texas arrest, she then has the disorderly intoxication and paraphernalia possession at a California arrest. Then we move over to 2020, where you get her second DUI arrest in Texas, which then has the Vegas domestic violence battery violating it, which was in 2021. And now we have this case. So, Judge, she's shown that not only is she continuously picking up these offenses, but she's also violating the release of those cases before they're handled. The defense came up here and has told you, they've gone through the process of trying to close out those matters, but that doesn't change the fact that there's a current warrant for her arrest for skipping town and taking years to try and handle that DUI out of Texas. She's found in Hawaii in a drug rehab facility. They weren't able to find anything apparently closer to their home. And certainly, this is a situation where if she wanted to, she could leave just like she did for that. They talk about the fact that this was a long investigation. And Your Honor should take no credence to that argument. The reality is, investigations take time. Has nothing to do as to her flight risk or her danger to the community, but what does matter to the danger of the community are prior incidents of domestic violence, including the one that was entered into evidence today, where she was a child that involved her mother and her sister. So there are certain situations where even when she's with her family, she has shown that she is violent, and that not only is the community not safe, she's not safe, and her family would not be safe. So the fact that she has this huge alcohol problem as well as drug problem, there's no guarantee that she's able to beat this, to get on top of this. Anytime she has some sort of relapse, if she were to be out, these types of situations continue to happen in her life. And she's shown that this is what continues to happen. So, Your Honor, we've put forward to you everything that she's done, not only to Christian, but also that she's shown throughout her life in interacting with her family. It shows that there are no reasonable means to ensure not only the safety of the community, but also that she will appear in this court. If Your Honor were to release her, there's no guarantee she's coming back. So, because of that, I don't believe there are any reasonable means that this court could find other than holding the defendant no bond in this instance. And this goes to the same argument that if Your Honor does find that that perhaps the state has not met its burden of proof evident presumption great as to second-degree murder, defense conceding this idea of manslaughter, Your Honor can still hold her no bond as a danger to the community under the substantial probability under pretrial detention, because manslaughter does fall within the dangerous crime statute, and she, under the same category, this phase 2 argument, you cannot ensure her presence before this court as well as the danger to the community. So for those reasons, the state would request that Your Honor continue to hold her, that Your Honor find that the state has met its burden of proof evident presumption great as to the charged crime, and that Your Honor continues to hold her. Thank you.
May it please the court. First of all, Your Honor, thank you very much for the opportunity to address the court regarding this very sad occasion on behalf of the Ambaselli family, some of which who are appearing by way of Zoom, who's having to relive this nightmare. Their life was shaken on April 3rd. The reason why this case has received not only national attention but worldwide attention is because no family should have to go through what the Ambaselli family went through. And let me walk you through so that you can understand how devastated they are even today. They first learned of Ambaselli, who they affectionately known as Toby. Christian, his dad, when they got a telephone call from someone requesting permission to donate his organs, they immediately thought it was a joke, unaware of what had happened, flew to Miami. They had met the defendant once, didn't know that much about her. Christian and the defendant had moved to Miami only January of this year. So when they flew to Miami, they wanted to know if the defendant was in custody. She was not, had not been arrested. I was then engaged. set up a meeting with the state attorney's office and to unfold exactly. And the first thing I did was apologize as an officer of this court, as a lawyer in this community, as a former prosecutor, knowing that that's not the way we do things here in Miami-Dade County. I was embarrassed. And then they learned the tragic news as to what took place. I believe, unfortunately in this case, we too often assume, because we know about females being in an abusive relation, but we don't realize that men also find themselves in abusive relations. Mr. Umbaselli is dead today because of the toxic relationship and that he was in denial of being physically abused as well as mentally abused. Let me give an example, just what I mean by the physical and mental abuse that he endured as it relates to this case. He was referred often as the N-word. That still didn't stop him because of the love he had for her. The story that is being painted is that the defendant was the victim of violence, mental. But listen to her words as presented in the record on behalf of the defendant. Come here, let me slap you. Those are the words from the defendant to Mr. Umbaselli. Is that the language of someone who's afraid for their life? Someone who's a victim of abuse? Absolutely not. That is the language of someone who is controlling. Let's look at other words. I hope you enjoy your stay in the hospital. That was just one of the second times that she had used physical force, where he had to go to the hospital. And how do we know that he was the victim of abusive relation? When he went to the hospital, he didn't tell him who was responsible for why he was at the hospital, even though he was cut up in his face.
Your Honor, I'm just going to object. Mr. Hanfield is an amazing attorney. We all know his reputation in the community, but he's here in the role of a victim advocate. He's not here to comment on the strength of the evidence, the strength of the state's case. That's a legal argument that the state attorney had an opportunity to address. And he's talking about the weight of evidence and what the evidence shows, which I think is improper. With all due respect, I respect Mr. Hanfield greatly. I went against him when I was a prosecutor, and he tooled me around the courtroom several times, but I think it's improper, so I'd object.
Obviously, none of Mr. Hanfield was saying has any evidentiary value, because I can't weigh it when it comes to either the state's burden or the defense's burden. Under Marcy's law, the victim has a right to be heard at substantive proceedings, step in substantive proceeding. I agree, though, that the analysis of the weight of the evidence probably not, maybe not as much of the role of the victim's advocate. I'm still gonna let you speak, but I do agree that maybe, under the singular portion of Marcy's law that allows the victim to be heard during these circumstances, it goes less to legal argument and more to the victim's point of view, but I do still want to hear from you, but I think we have to curtail so much of the legal argument.
Okay. And Judge, I'm going to connect it all at the end. That's why I want the court to have an understanding as to what my client family has had to endure. They believe that she should not be given the privilege of a bond. Why? First of all, she has already demonstrated that she doesn't respect the law. There are 3 cases when I was in LA myself with my investigator. I sent him to the courthouse just to check to see. And sure enough, we discovered, for which was provided to the state, there was an outstanding warrant for the defendant's arrest since 2015.
Judge,
A
I'm
case-
just objecting to this. This goes completely to legal argument, not representing the victim's voice to be heard under Washington.
What it shows, Judge, is this. If I imagine for one moment that it was Mr. Ambaselli, the defendant, and God forbid, Ms. Courtney Clenney, the deceased, it is no way in heaven's name I can even imagine any circumstances where a judge would have released him. And that is based upon a pattern. And the reason why there's been so much outrage and concern about this is because it is clear that there is a different benefit that she has received that most people don't receive. The Ambaselli family only wants that their loved one and that family and this defendant to receive equal treatment under the law. Equal treatment under the law looks at the fact that when this incident happened, I have not heard the state nor the defendant indicate the point. The first person, I'm sitting here, and the first person after a person has been stabbed was not 911 call. You got someone dying. There is there was nothing, there's no junket.
Objection. It's just going above and beyond.
I actually objection when allowed this last time.
If we get, this system is blind justice. Everyone should be treated equally. Whether the deceased is a male or whether if the deceased was vice versa being the defendant. She left, she lives in Texas. She was apprehended in Hawaii. The defense has indicated that she is now willing, we in 2022, so some 7 years later, are going to try to resolve an outstanding warrant that she knew was in existence for 7 years. If it was my client, he would be in custody. I just ask, Judge, on behalf of the family, I ask this court to take their consideration under consideration, and regardless of the fact that she may be privileged, we want her to receive the same equal protection as if the shoe was on the other foot. And I thank you so much for the attention that you've given to me.
All right, so that is going to conclude for today. I'm not making a decision today. I'm going to expedite transcripts of the last 2 days on the order. I'm looking findings for both motions. And hopefully we can get the transcript soon, but no decision is going to be made prior to Thanksgiving. So I know that might have been a time, yes, that's not going to happen. But I will resend this in 3
Yeah, December 18th.